Board Member McClellan.
Here.
Board Member Rankin.
Here.
Board Member Shuffle. Here. Board Member Schroeder.
Here.
Thank you. First item on our agenda this morning is a vote regarding the Code of Ethics. I'll turn this over to Counselor Tolson, please.
Good morning.
Good morning.
Members of the board, you'll recall, I think we've been here a couple of times with the draft Code of Ethics, so I won't belabor the fact that it's been edited and updated to basically align with current state law. The big deficit, between the version we had and the way the law has changed is that individual board members can no longer go seek independent legal advice from the Secretary of State's office. So that changes in there. In June, when we discussed this down in Salida, what had happened, that Code of Ethics is an unusual document because back from time immemorial, I guess, we had attached the statutes that it relies on to the code. And so that when we went to update the code, we had also red lines reflecting changes in the statute. That created sort of its own confusion. It was easy to deep dive into why are all these statutory changes here, let's talk about them. So my understanding of the instructions from this board was let's just remove the appendix and just have the Code of Ethics be standalone. There's certainly no reason it needed to have those attachments, and those could create their own confusion because, as we all know, statutes change every year, and you all probably don't need that to be coming back to you every year. Fundamentally, your legal obligations are defined by existing law, and if it changes, that's one of the things we're here for to hope you know. So the draft that is before you now for approval and vote is the same version you saw in June, but without the attached statutes.
Thank you. Board Member Flores.
Excuse me, do you mean that all those statutes that are this thick will not be in it?
Right, so it'll just be a very few pages describing the obligations in sort of plain language.
But those are so important to us.
Well, if you all want, I think that is your call to make. If you find it helpful to have them directly in the Code of Ethics as an attachment, we can do
And
that.
it's that one, that was what color this year? It was mahogany? And-
Well, there were excerpts, not the whole book, but there were excerpts in the Code of Ethics. There was an attachment to the draft revisions to the Code of Ethics that included, as an appendix to that code, all the statutes that were referenced in it. So you could sort of flip back and forth.
So that book is not going to be what we get this year?
No, the book will be the same. This is just about what your Code of Ethics document
Okay.
will look like.
So if it's not in the ethics, then it's,
You'll still be governed by the law, it just won't be in that format.
okay. You had me.
You'll
Okay,
still get
'cause
the
that
book.
book is,
For your light reading when you're having trouble sleeping.
that's right.
Board Member Goff.
Thank you. I apologize if I just missed this in prior conversations. Page 4, the ex parte communications. I noticed on there it refers to educator licensing or charter school action. And what we don't have in there that we have been operating with under ex parte is our accountability hearings. So why is it not there, or hasn't it been added, and should it be, or is it someplace else where that's spelled out?
That is a great question, and Board Member Goff, that is actually something that I noticed as we were preparing for this meeting. Is like, oh, we could have added that there. Now you have operating procedures, which is the
Right.
second document and longer, that speaks with greater specificity to your quasi-judicial actions and does mention accountability acts. The hard part with a list like this is when you're functioning as a judge, and the most typical thing had been educator licensing and charter appeals, and then now we've seen accountability matters. There are several other statutes that give you all authority to resolve disputes in that capacity. And anytime you're sitting in that sort of black robe equivalent capacity, you don't want to be engaging with the parties ex parte. So we don't have an exhaustive list in there, but the ground rules are the same. We could add it, and I had honestly pondered doing that. It was before this board meeting. I thought the last thing I need is to make a substantive tweak when we think we were just back here about removing the appendix. Because whether it says it or not, that obligation remains.
Right. Would it be a lot of trouble to add it?
Not at all.
Yeah.
Do we need, the question is, do we need, I think Board Member Goff's question is,
Yes, do we need
to
it? I
Well-
think it would be helpful for ready reference, both for you all and for public transparency. So we could just add proceedings under the Accountability Act.
Yeah.
So where did we actually get, didn't we make some changes in our appeal process for the accountability rules?
We
And didn't we relax?
We didn't, I'm sorry.
We relaxed, in the accountability context, you'll recall the first time those came to you, and it's because the statute sort of drove it. It created this party versus party where the department was one of the parties. The statute changed and your procedures acknowledge that, so department staff is much more available to you for technical advice and consultation, and the only party in front of you in that quasi-judicial capacity is the district and school.
Yeah.
So there is
There is a
loosening,
change.
we don't have the same, we're not hamstrung in the way we were in the spring of 2017.
Right.
What do you recommend, Counselor? And where else, I mean, I appreciate that this was brought up, but you're suggesting there are other situations where this could occur. I'm wondering if it's a little safer to put something to the effect that, or other ex parte situations, as opposed to having a laundry list.
We could, instead of having any examples, it could simply say anytime the board is hearing a matter in a quasi-judicial capacity. And that might be the safest of all. You know, we just had something filed, and we won't get into it, with the board office under a statute, and it's going to come before you quasi-judicially, and none of us can find the last time you've ever heard one, but I bet none of you all were here.
Right.
And I certainly wasn't.
Board Member Goff, what do you think about that idea?
Well, I, first of all, have always been an appreciator of avoiding the laundry list syndrome.
Yeah.
So I understand that, but I do think for sake of public education and information, if it had been in there, perhaps it would have set us away from a lot of the complications we've had overall. But I agree, if
Yeah.
anything nebulous enough to be specifically referring to something would be fine, and it could be in any other matters requiring ex parte or calling for quasi-judicial situations. I'm fine with that. I just found it interesting that we've been. Okay, thank you.
Where are we?
Well, I have nothing else for you all. If you, whether in the context of a motion or informally want to give some direction regarding that small piece, the nice thing is if we can somehow embed it in a motion, we might be able to get this thing off your agendas.
I think that would be a good idea. That was really quick. All right, I would appreciate, any other questions, first of all, folks? So I would appreciate a motion.
And just if it helps, I think just one of two ways, because I've heard two different things. One is to just simply add the reference to the Accountability Act. Another would be to remove any specific example and more describe just the capacity in which you're sitting.
Right, leave off the laundry list.
Yeah, and if the motion specifies those, I think we can make the correction.
Otherwise,
But-
maybe I can change it to it.
But
Board
what
Member
about
Flores?
the laundry list for some people that come in and that are new and that may need to have the laundry list?
Some people that come in that are new, who are those
New
people?
board members are you talking about?
New board members will be certainly
Well,
trained.
are you saying that then by next year, we will go over this again and then?
Anytime there's a change in the board composition, there's a
Well,
one-day
that's what
training.
I'm saying, and that-
Including from our counselor.
And
So-
that that laundry list, maybe it could be an appendix of the laundry list. I don't know, all that helps. And excluding stuff that, I don't know, some of us find helpful, may not be helpful to many of you, but to some of us, we find it helpful.
The concern, Board Member Flores, is that when you have a laundry list, there's the assumption that you have everything. And things come up and things change. For example, apparently we have something coming up that we've not had before that would not have been on the laundry list. And so it's safer
Well-
to be guided by counsel when we are in ex parte situation.
It is good to be guided by counsel, but it's also good to have examples down of what might happen. And I'd like to be safer and sure to have everything that would be helpful than not to have things
Okay.
that,
So I have a motion. Board Member Durham?
Let's see. I'll move the adoption of the revised code of ethics. And I'm gonna ask, I have a motion that includes the laundry list, because I don't think it's that long. It's about 6
Good.
items. It's not like 15 items.
thank you.
So I think it's just as simple to list them as it is to list the kinds of proceedings. Frankly, you could do both and it wouldn't clutter the document, especially as short as it is. So, but there's no harm in a laundry list that's not pages.
So what's your motion, sir?
That's my motion.
And I
Include
second
the-
it.
Include the list
It already is in the list, except the list is incomplete because
and,
we,
yeah, make the list.
We can do that. That's fine.
could you articulate how we, what
Here's,
the completion
here's
looks
what
like?
I would envision, is for it to say, for the purpose of this code, ex parte communications are contacts between a party to an action and a state board member acting in a quasi-judicial making capacity in that party's case. Quasi-judicial matters include, like, I would actually create a second sentence, because otherwise,
that.
I think that's gonna become a pretty convoluted
Include? Yeah.
paragraph.
Steve?
Yeah, I do. Struck me, I read it, it didn't pop into my mind at the time. Doesn't it preclude comments not just from the parties, but from third parties?
It would, yeah, that,
Because, I mean, if it doesn't, then I can certainly lobby my colleagues, and someone who's not
right.
not a party could certainly talk to many of us, and there are people, plenty of people out there who are parties who have plenty of information about this issue. So I mean,
Right.
it should be clear one way or the other.
Sure.
Because if we can talk to third parties who are not direct participants, then that's significant change.
No, and and the intention here isn't to change it. I think part of it is maybe this one's a little overly lawyer pinheaded view that the phrase ex parte by definition is about parties, but then there's a separate matter, which is that when you all are exercising authority, particularly where you're confined to the submissions of the parties or to a record, to not consider things from outside that context.
Yeah, because we don't allow public comment on here, on those issues.
Sure.
So I think it really does need to be one way or the other,
Okay.
and clear as to which it is.
What if I created an edition that I think does that and circulated early enough to see if we could have this on consent in a future agenda? I want to be sure that it's addressing the concerns you've raised, even though I understand that we're now on conversation number 3 about it, and,
It's okay.
would that
That's okay. That
work?
part's okay.
I don't think
Yeah.
we're in any hurry on
Yeah.
this.
Yeah.
It's-
Yeah.
We have something in place that's actually perfectly adequate,
Mhm.
so.
Okay, will do.
So it was an information item, turns
Yeah,
out.
But yeah, I do think we do not, I'm sorry I didn't catch that in the language earlier.
Nope, that's totally fair.
Thought you did.
Any other comments regarding this? Thank you.
Okay.
Enjoy.
I agree.
Thank you. All right, the next item. It's an information item regarding the charter school appeal procedures. I'll turn this over to Mr. Peters.
All right, hi everybody. We were back talking about this in May previously. We had a conversation there that lasted maybe 25, 30 minutes, and you asked to lay it over until this meeting so that you could take 2-3 months to think about it and review it. I've made a few changes to the draft that you saw in May, reflecting comments mostly from Board Chair Schroeder and a few other comments from the field. So you should have in front of you both a clean draft and a red line draft that shows the changes from May. And then you should also have a copy of the old procedures that we're trying to replace, or that I would like to replace. And then this morning, it's not up on board docs, but this morning I handed out a paper draft to respond to some further comments that we received from board member Schroeder. You should see that in front of you. It just says additional proposed change to limit the size of the record. I handed that out in paper copy. We'll come to that when we get to that portion of it. In May, however, I believe I went too fast through this. And so I'm here now with a PowerPoint to walk you through it a little more slowly. And that's good news because lawyers bill by the hour. So, all right.
Oh, no, that doesn't help you.
All right.
Nice try, though.
It might help you.
All
Oh,
right, so
hey,
why
they're on.
are we here in the first place? These procedures have not been updated in 11 years, and at this point, there's a pretty sizable gap between what we do in practice and what these procedures call for. For example, we do a scheduling conference with the parties when they file the notice of appeal, in which we make up a brand new briefing schedule that looks nothing like the briefing schedule that's in these procedures. And we do that because, as a practical matter, these procedures are just not useful as written. They're confusing, or at least I find them confusing. They're incomplete. There are things that you have the authority to review that are not in here, and then there are different provisions that kind of duplicate and are redundant, and they're just more burdensome than they need to be. So at a big picture level, the first change that I have proposed making is to consolidate. You have two different policies currently. You have one that governs everything that can come up under two different statutes, which is contract disputes. So between any school, whether it's a district charter school or an institute charter school, if they have a dispute with their charter authorizer over what their contract says, that's a dispute that comes to you eventually. You've done it a few times, probably not very recently. And you have your main policies governed that, in addition to charter appeals of the normal variety out of districts. So first appeals, second appeals, whether it's an appeal over the contract or over the application, or over a unilateral condition. Those were all governed by one policy. And then you had a separate policy that governed CSI schools just on the high stakes stuff, the application and the contract and revocation. I just wanted to consolidate them all into one thing so we don't have to even be aware that there's two different policies out there. And then there's another type of appeal of which I have seen one in the 2 years that I've been here. They ended up settling it before it came to you. But there's an appeal for financial disputes that we don't even have a policy for. So I thought I'd try to consolidate that in here as well. The last time we saw it, we just made up a procedure for all of about 3 days before they settled it. So I'd rather not make it up. When we were here in May, we discussed the hearing format. Your current hearing format, like you'll have today, is kind of an appellate court model, where the parties each get an allotted amount of time to talk, and you get to interrupt them and pepper them with questions as they go. We discussed changing that to more of a legislative hearing model, in which the witnesses each get a limited amount of time, but they get to speak uninterrupted. And then each of you gets an allotted amount of time to ask questions uninterrupted. And in May, you suggested that you liked that idea, so I put that in here. The new model, or the new draft, will, makes that change. And then finally, this is about 6 pages shorter than the old one, because I took out all the stuff that just copies and pastes from statute, because I don't understand why we do that. Section A of the draft is just getting started, so applicability and e-filing. Right, so as I mentioned, I've got a list of statutes here. This is every statute in which you get to review a decision that an authorizer has made that a charter school objects to, where they have a legal right to come and ask you to review it. There are a few things you do with charter schools, including quasi-judicial things, that don't kind of fall under that concept. This strange creature that Julie mentioned earlier that we haven't seen in 15 years, you'll be seeing later this year. That's not going to be governed by this because it's not a dispute between a school and its an authorizer. It's a dispute between a school and somebody else in the world. Also, exclusive chartering authority, that's not really between a school and an authorizer. That's between an authorizer and the community at large. And so that's not governed by this. This is just about fights between schools and its authorizer. we're moving over to a pure e-filing system with this. We used to require them to file 3 copies of everything in paper. That's an example of stuff that the policy's called for that we don't do anymore. You know, every charter school appeal comes in and we get on the phone with the parties and we're like, can we just all agree to waive the paper filing at this point? And they agree, we agree, we might as well just put it on paper now, or at least put it in the rules. All right, so that's section A. Section B is initiating a case. Right now, I haven't looked at the notice of appeal for the one that you have today, but the rules or the procedures that you have encourage the parties to put a lot of content in the notice of appeal that then just gets copied and pasted and put in their opening brief. And that's a waste of time, I think. So this new draft just calls for a notice of appeal to be 2 pages or less. Just give us the basic bare bones information about who's at issue, give us a copy of the local board's decision, and that's it. And then, you know, all of the argument can go in the opening brief where it belongs instead of in the notice of appeal. The goal here is to just
Quick
make this a
question.
little simpler.
Is there a time limit between notice of appeal and opening brief?
Yeah, there's a briefing schedule that we'll get to
Okay.
in section D. So,
Scratch the record, I'm sorry I asked that.
or section C, the next one. So,
In terms of the, a copy of the board action,
mhm.
does it require that the board act by resolution?
We can strongly encourage it. I'm not sure you have any authority to mandate it. And we could try to build in a procedure that says, you know, if you don't act by resolution, we're gonna shake our finger at you and get kind of mad. The problem is you don't have any rulemaking authority under the Charter Schools Act, so this is just a purely procedural thing. I can add something in here that strongly encourages them to do it.
We had a long debate yesterday about whether or not it is required. I think it's an open question at best,
Okay.
and a requirement more likely, so. In part because if there is no board resolution, then there is no record as to why the charter school was rejected. And if there is no record, then it's difficult to then provide briefing on exactly what was done that was not in the best interest.
Right. I understand the concern, and I can see why it would be very bad practice for a district to move without a written resolution.
I mean, just talking about Douglas County, picking somebody at random.
Yeah, randomly, yep. I understand the concern. I'm a little bit constrained in what we could do about it in these procedures other than strongly encourage it. I'm not aware of a mandate that they act through a written resolution. If you guys had a conversation where it's an open question, then that's something you probably ought to take up during the appeal hearing later today. In that specific case. In these, I think what we can do is we can strongly encourage it. The problem is the legislature just didn't give you any rulemaking authority.
Yeah, all right,
So-
thank you.
Board Member McClellan?
Thank you, Madam Chair. I assume that I know the answer to this question, but I just want to double check. With respect to the 6 minutes, I'm almost afraid to ask this for our Director of State Board Relations and her assistant, who I assume will be responsible for timing us to hold us to that 6-minute limit. Can that be broken up? Because sometimes in the course of conversation, a point will come up that will trigger additional questions in a board member's mind. So my hope is that we don't have to do all 6 minutes, but that we can reserve a few minutes for follow-up questions as the conversation progresses. Am I correct?
So legally, you can do this however you want to do it. As a practical matter, that strikes me as quite difficult, but that's a conversation we can go back and have with Ms. Maramba.
Okay, then maybe I'll put everyone in the room on notice that maybe we could do 3 and 3 or something like that, because there is rarely a robust discussion that doesn't trigger more thoughtful questions as the conversation rolls along. So at least 2 bites at the apple would be nice, but that's just my thoughts. Thanks.
Board Member Flores?
May I entertain that maybe we have 35 minutes of this? Maybe we have 35 minutes of discussion whereby one person cannot hog most of the discussion.
We have, it's designed 6 minutes per person.
Well, I understand that, and hopefully people won't go for 6 minutes, and our Director of Board Relations will keep us to that, so that people will not go over 6 minutes, but, so that,
Board Member McClellan's question relates to how we use those 6 minutes. Must we use them just in one iteration?
yeah,
as in
and that's what
going
I'm
on the
saying.
table?
If we have them broadly and say, well, the 7 times 6 is what? 42?
It's still 42.
So we could have 42 minutes, and then you could have three minutes, but so that
And you
one
could have-
person
You
doesn't.
could have 30? No, that's
No,
not
I
how
don't
it's
want
designed.
30. I'm just saying that would just give a response to,
Just as a point of clarification, I support limiting each board member to 6 minutes. I'm fine with that.
and I do too.
I just would hope that we don't have an obligation to use all 6 minutes at one time, so that in the event that something comes up during a robust discussion, that we can ask an intelligent follow-up question if necessary, that's all.
And I'm allowing for that in giving us 45 minutes, so that, for the board, and then somebody not take more than 6 minutes. That's,
So, Mr. Peters, I don't disagree with you that Board Member McClellan's request could complicate the soup a little bit. On the other hand, I'm wondering, Ms. Maramba, when we go through and we're finished with questions, you could tell that individual how much time they have left of their 6 minutes, thereby giving them another opportunity to speak if they want it. Is
That's
that
what
gonna,
I
is that
said.
gonna drive you nuts? Okay, let's try that. I
Yeah.
think if it
Try my
turns
idea.
into a mess, right, and we won't try today, right, we're under the old rules today, but, yeah, I appreciate that you think we're just gonna kill her, that's all.
That's fine by me. So. All right, section C is the briefing schedule. And so, as I mentioned earlier, we do a phone call with the attorneys for the parties immediately after the notice of appeal is filed, usually within a couple of days. And we agreed to a scheduling order that is normally issued by Ms. Maramba, in which it tells them when their briefs are due, when the record on appeal is due, when certain motions are due. I have not changed all that much from your current procedure about the scheduling conference, except that I have coordinated it better with the filing of the record on appeal. So previously, under the old procedures, the current procedures, the charter school has to request the record on appeal from the authorizer within 20 days of the authoriser's decision, which is a mandate that we've asked for that doesn't exist in statute. And some schools haven't even made up a decision about whether or not they're going to appeal within 20 days. So for example, we had one filed, we had a notice of facilitation filed about 2 weeks ago from a school that said that it had requested the record on appeal in order to preserve its right to appeal, even though it hadn't yet decided if it was going to, and then it and the authorizer decided it was going to go ahead and move into mediation with it instead of bringing it to you. That's a waste of time. So I have these currently drafted just so that they ask for the record on appeal as soon as they can, but no later than when they file the notice of appeal. And then they have, I believe it is 1 week after the notice of appeal is what I have written here in order to actually file the record. And then once the record is in place, it begins the briefing schedule. This looks a little bit more normal, like normal appellate legal procedure, and I think it's probably going to be less burdensome for the parties. And in order to accomplish it, I have sort of an expedited briefing schedule compared to what we currently have. Go on.
Mr. Peters, just to go back to the ex parte, when a charter files a notice of appeal, that's when that begins for communication. Am I correct?
That should be right, yes.
Okay. So that's when Ms. Maramba notifies us that there's been a notice of appeal, and even though we have no idea who or what or why, at that point, we can no longer ask questions or accept input.
That's correct, Board Member.
Thanks.
So that's the briefing schedule. The next section is rules for the briefs and motions. You used to have in here kind of your own format that you wanted, and it was probably based on what we used in courts 20 years ago. And so, talked about sans serif font and 12 points of this and 14 points of that and how many inches for the margins. And instead of using up half of a page to say that, what I have in here now is just a cross-reference over to the appellate rules. And any lawyer working a charter school appeal is familiar with those and knows how to format his brief. Also, I shortened the page limit for the reply briefs. I believe under your current rules, the opening brief, the answer brief, and the reply brief can all be 20 pages long. I shortened the reply brief down to 15, kept the other two at 20. If you guys want those shorter, we can make them all shorter, right? It's whatever you want them to be.
That's fine.
They bill by the hour, huh?
You don't, though, so if you'd like to read less, that's on you. And then I have something explicit in here about allowing the State Board Office to handle non-substantive motions. And that's just conforming to what we already do. The parties ask a lot of stupid questions, and if they're stupid, we don't bring them to you. So now it's in here officially. All right, E, the record on appeal. The draft that is on board docs does not do much of anything to change the content in the record on appeal. It does ask them to do a much better job organizing it than some districts have done in recent appeals. And then I tried to create a process for resolving disputes over what should and should not be in the record that was slightly more burdensome than it was in the past. It used to be that if the parties disagreed about what should be in the record, they would just start arguing and they'd file motions, and Commissioner Anthis has to resolve it. We still have that in here, but I tried to make it a little bit harder so that they get to the point where they're bothering the commissioner less frequently, trying to encourage them to resolve it on their own more readily. That's the draft that's on board docs. I mentioned this morning that I handed this out. This is additional edits. We received an email from Board Member Schroeder, I think last week, asking about the size of
Yeah, when I started reading,
record.
probably Friday or Monday.
Yeah, so the record in today's hearing is what, like 1,400 pages, I think. And so what I have here is some draft language to try to encourage the parties to limit the size of the record. It's a little bit tricky because the parties are unlikely to agree on what can be cut, and we don't want to make it we don't want to give it a lot of teeth, because that'll give one team an opportunity to really abuse the other team.
In part, the record on appeal may not be controllable because you're going to reference documents that you had no ability to create or you had no responsibility for creating. So trying to limit it can certainly lead to a result where not all of the relevant material is presented because they have no ability to control it. I think the
agree with you.
trick is to learn to, when you're reading it, to know that you don't necessarily have to read every word of what is often quite
Right.
redundant material. And I think that's unfortunately a lesson for us, but, and I think it is a good idea to try and encourage them to limit it, but to require them to limit it is not practical because they don't create it.
Yeah, could you go back, please, and explain who's responsible for what in the record?
So
Looks
the-
like the district?
Yeah, the district or CSI is responsible for compiling the record.
Right.
The school has to request it at a certain point in time, and then the district compiles it and files it.
So is there any guidance for the creation of the record, for how it should be organized?
Yeah, so there's a list in your procedures, and I've kept that list. I've rephrased a couple of things as part of my effort to make it apply to both districts and CSI, and any other type of an appeal that you can hear. But the list is substantially the same as it used to be. And it says, first, the charter application. Second, the resolution or other written grounds for the determination. Third, the report or other findings of the District Accountability Committee. Fourth, any written record of the board meetings. Fifth is any written communications, like emails, letters. And then sixth is more of a catch-all, just anything else you need us to read. That's already in here. My new procedures tell the parties to organize it better for you, so put them in that order with bookmarks page numbers and things like that.
And where does the concern come from the charter applicant about the record? I'm trying to understand I think if I understand the process better,
It is, many of the disputes that we see over the record is normally the charter school advocating for including some emails or some other communications that the district has not included in the record and that the charter school thinks is relevant.
So is there a place for the charter school to include what they want to have in the record?
Under the current process, the charter school just has to ask for it, and then if the district doesn't agree, then we have to go and they file motions and the commissioner has to resolve it. And she does this in probably half of your charter school appeals, whether you're aware of it or not.
No, we're not. That's why I brought this up, right? It's
Yeah.
just this overwhelming
Yeah. so
amount of
that-
material, especially since the briefs refer to the record.
yeah.
Danny's memo to us this time referred to the record.
Yep.
I started reading the record. I was reading things that probably weren't, I mean, it's just,
So in about half of your appeals, the commissioner has to issue some kind of maybe a third, maybe it's not quite half. So maybe a third of your appeals, the commissioner has to issue an order, or maybe we get into a discussion with the parties about what should or should not be in the record, and we can try to get it resolved before it comes to the commissioner. But these discussions happen in several of these cases, and I don't want to say always. It's normally the school asking to include something that the district has excluded from the record. What I've tried to do is force them to file, in the new draft, I have a procedure in here where they're required to file whatever it is they can agree on, and then go back and continue discussing the stuff they can't agree on. It's intended to sort of level that playing field so that it's as often the district as it is the school that's
Right.
the advocate or the proponent of some new material.
thank you. Board Member Flores.
I agree with Mr. Durham, that I think that, 5 pages, 10 pages more, even 20, 30 pages more, that's not going to be, if it needs to be there for the reason of meaning and substance, I think it should be added. And
I'm
so.
not arguing that. I'm saying 1,400 pages seemed a lot, and there's a ton
Well,
of redundancy in there.
Well,
having
that's-
spent time reading it. So to the extent that we can
That's true,
minimize that.
but we were talking about 15 and 20. And so I agree with you. I mean, that was a
Yeah,
lot
I'm
of.
talking about the record. I'm not talking about the briefs.
Uh,
15, 20, I'm,
And one of the things that I think is important in some of this, curricula is so important. So why not add some version of what they're going to use and such if
And that
if
should
they
be-
are?
That should be in the charter
Should be
school
in it.
application, which
Yeah.
is a required element of the record.
That's right.
Yeah,
And
it's
Let
there.
me,
It's
let me
the-
describe what I've done, and let's see, I believe what I'm proposing here in the written one that I circulated meets Board Member Durham's and Board Member Flores' concerns. So let me describe it to you real quick.
Thank you.
First,
Before
the
you
version
describe it,
that's,
let me ask one
the
question.
version that's on
though.
board
It's-
docs.
Just a minute.
So-
Do you, do you require the district to disclose emails and all the other relevant, so that it would be very much like a discovery in a civil case? Do you require that?
We do not have any mechanism in here for that. The district is, let me rephrase it. The district is required to file everything that's described in here, which includes all of their emails. Now, in terms of enforcing it, because I get what you're probably asking is how do we trust the district to do so? There's no enforceable discovery. Many charter schools do file Cora requests, so they handle it outside of the litigation. Right?
And if they get some, let's suppose they obtain some through the Cora request, do they have a right then to augment the record?
Yeah, that's the process we've discussed where they file a request to supplement the record, and then the district, if it disagrees, it goes to the
On what
commissioner.
basis could the district agree if there were in fact things that they didn't?
Yeah, it's normally relevance, so they'll say that it's irrelevant to the issues before you, and then we write a quick memo to the commissioner in
But
which we
it's-
explain it.
How could it be irrelevant if it references the charter school?
We normally grant the motions to supplement. So,
So it might,
I think in the
might-
2 years I've been here, we've denied one, yeah.
And I think that was a district we denied.
I think that's right.
Yeah.
There's a pretty serious thumb on the scale in favor of admission, so.
Yeah, and there should be. I just wonder if the rules shouldn't contain a presumption
Yeah, and I
that,
believe that they do.
that all means all.
Yeah, and I believe they do. You know, that's pretty clear in here that we want everything.
But a third of the time, you still don't get everything. So the
A third of the
districts
time,
are,
a third of the time we end up in an argument about whether or not we have everything. That's true, right? And we normally resolve it in favor of admitting the records.
so a third of the time, and generally speaking, it's resolved against the district, they have withheld things that are relevant, that the commissioner finds to be relevant.
I'm nervous about this third of a time thing because I don't even know that it happens that often. And
All right.
we almost always do in favor of adding to the record. Certainly the one time we denied it, we actually denied it again, that it was admitted and that, so I just don't think it's a big issue.
Yeah, I'm also uncomfortable stating it quite as strongly as you just did, Board Member Durham. Anyway. So the new draft here that attempts to limit the scope of the record, which is not in the version that's on Board Docs. The version that's on Board Docs kind of carries forward your current practice, which leads to 1,500 and 2,000 page records,
Yeah.
right? This written one that I circulated this morning just includes a paragraph that says that the parties shall meet and confer with each other and talk and try to come to an agreement about what they can exclude. If they can agree on it, please exclude it. If you can't agree on it, it's coming in. And then there's a second paragraph that I added here that tells the parties to use, and it says in quotation marks, pin sites. That's lawyer talk. It just says, tell me which page in the record you're referring to, right? So in writing your briefs, instead of referring to a 30-page span in the record, you should be referring to specific pages in the record. And then it warns them that a failure to refer to specific pages may waive any arguments based on that, right? So the 300 pages that we don't care about, we're just putting them on notice that you're probably not going to read those if you don't cite them in your briefs, right? So I don't think this is putting a lot of teeth in to limit the scope of the record. If it's too many teeth, that's fine. We just don't need to adopt it. But
Thank you for doing that.
all right, so that's the record on appeal. The conduct of the hearing, we got into this earlier with Board Member McClellan's question, and I flagged this at the beginning as one of the major changes. The current draft on Board Docs is trying to move to this hearing model, this legislative model, where you each have allocated time. It sounded at least a little bit like Board Member Flores prefers the current format, maybe, but this is your call to make. In May, you said you liked this idea, so that's what the draft currently says.
No.
And then finally, subsection, or
Do you not have a suggestion?
I'm sorry, let me go back to F real quick.
But
Well,
30
I
minutes to
think-
45 minutes is a little different.
I think the question is, we spend a considerable amount of time saying and making sure we follow the rules, that this is a quasi-judicial proceeding, and then we have a hearing that's legislative, which makes absolutely no sense, but
Exactly.
that's fine. If we want to make absolutely no sense. Either it's judicial in nature or it's legislative in nature. And it's clearly under the law, not legislative.
If you prefer the current model where it's 30 minutes each side and you get to interrupt them with questions, that's your
Well,
call to
I
make.
actually don't necessarily prefer the current model, because there's a certain amount of disorder to it. But I think there are several problems with the specifics that I'm going to talk about when we get to the appropriate time.
This is not it?
This is probably it.
This is it?
No, I don't think we're there yet. Go ahead.
Well, all right, before we,
And by the way, the legislative hearing model, at least I think it's still true, it was certainly true when I was there. Witnesses were interrupted all the time.
yeah, and I think
So
that's
to say that it's a legislative model, it's not similar to any legislative model I've ever
so
seen.
it's a distinction. So in Congress, when they do formal hearings, they normally allow the witnesses an uninterrupted moment to begin.
But it's a relatively small percentage of the total time, where in this case, it is even as set forward, half the time of the hearing.
That's 1/3, so each side would have 10 minutes here, which is a total of 20, and then you get 42 between the seven of you as currently drafted, and we can adjust.
Well,
that
I
however
usually
you'd
say 20 is half of 40, so, it's probably just what basis you want to calculate.
Well, the total is 62, right? So
I
20 is
understand.
1/3 of 62. But we can change those numbers. It's not my call to make, right? At any rate, aside from that big picture question, the only thing in subsection F here that I want to draw your specific attention to, this was not in the draft that you saw in May, but I added a sentence in here based on what happened with Liberty Common School at your June hearing. For a first hearing, you have the authority not to have a public hearing. You can just vote on it as a discussion and voting item without having the parties come. And since you did that in June, I added a sentence in here just to clarify that sometimes you might do it. If we're gonna add that sentence, I would very much like you to tell me what standard you want to use. So right now it says, on a first appeal under section 108(3)(a), the state board may proceed without a hearing on unanimous consent of the board members. We don't need that to be unanimous. You can make that whatever you want to make it. Majority vote, supermajority vote. We can take it out and just leave it silent. But if you want it in here, let's decide how we want it in here.
Let's go back. There was a recommendation that we not have the, Counselor Tolson, what was your reasoning for your recommendation in June? And then does that fit in here?
June was a relatively unique circumstance in that the debate, remembering that one was just about the length of the contract term,
Right.
not a grant or denial and a full-blown sort of fact-intensive best interest analysis. So given the narrowness of the question presented and the distance of the board meeting from the district, it was, as much as anything, a reminder that you could do it that way if the case was appropriate to dispose of that way.
Right. How would you write that in here? Under what circumstances? Mr. Peters has said we needed to explain under what circumstances we could do that. What would those be?
It goes back a little bit maybe to the discussion we had about laundry lists. Sometimes the more you try to describe how you exercise authority, the more confusing it can become. So frankly, I'd use something very general that'd be if the board determines that the matter may be disposed of without a hearing. I mean,
Based only on the briefs.
and can be, right, can dispose of the matter on the briefs. But, or you just may say, look, that situation was such an outlier, and most of these involve the kinds of exchanges you've had with
I know.
superintendents and others, so.
Board Member Dern.
Thank you, Madam Chair. First of all, I think that, kind of the basis of American jurisprudence is the opportunity to be heard. So this kind of provision has all of the appearance of a kangaroo court. And I don't think you can define it out any other way. Secondly, the one time we've used it, I think, led to a result where we unfortunately did not receive a significant amount of relevant information and had a decision that was based in theory on somebody's judgment of best practices, which I would suggest if you were to ask those same people about best practices today, you would not get that same answer. Because I've done some follow-up on that, and I certainly believe that you would get a much more tempered answer than you received in the exploration of best practices in the past. So, and in fact, that decision, that absence of hearing, probably will cost the charter school a couple of $1 million over the next 20 years. Now, some people may not think that's relevant, or that's a question of what's in the best interest, or whether or not the decision of the board was in the best interest of the community, of the school board in this case. But we really failed in our duty, and I was part of that, so I failed as well. I'm not casting any blame on anybody else that I wouldn't cast on myself in this particular instance. But this is very bad practice, and I think we ought to remove it when the
All right.
time for amendment comes.
Board Member McClellan.
Thank you, Madam Chair. The way that we are currently conducting our hearings allows for board members to basically interrupt to the point of filibuster the presentations of some of the parties. And so I'm strongly in support of these changes, and especially the change allowing for the limitation of time in terms of each board member's opportunity to question. And I hope that we can break those up. But I think when we have board members interrupting presenters to the point that they cannot get their presentation across, and then they simply don't get to present their side, at least not fully, that's something I hope that these procedures will help us to address. Thank you.
So if I'm following along, I'm going to remove this sentence about waiving the first appeal, or the public hearing during the first appeal. Is that right?
I think, let me hear from you guys. Agreed, not agreed? We're just talking right now about, where is it? Waiving first hearing. Should we take that out? Since a laundry list is a concern.
Is that what, we asked Member Durham, is that what you were referring to?
Yeah, I think
Yes.
that's, it's on the red line. I guess those pages aren't numbered.
Pages
So
aren't
it's
numbered,
the
Mr.
fourth
Peters.
page. It's under section F, conduct of hearing. It's the last sentence in the second to last paragraph.
Under F.
So,
And then-
as stated, it requires it would set a unanimous vote rule for skipping the hearing as you did in June. If you want to just take it out, that's, wonderful.
Was that your suggestion, Board Member?
I think it's better to remove it. I think everybody has a right to expect to be heard if they have an appeal.
That's fine. Board Member Goff?
Well, in that case, in June, here's where my wasn't confused, and I don't know that that's the right word. To me, the question at that time was, when we were talking about length of contract. So the question was not, to me, that did not relate at all to the merits of the school and the extension of that school in operation. That, to me, was purely a contractual issue, which after sitting here today and rethinking all of this, it goes back to what we talked about earlier about whether there is a separation, and in my mind there sure is, between the contract that's developed between an authorizer and a charter school and the merits of the case. And so I have had a hard time ever since connecting that. Why did we even talk about not having the hearing after we were all there and everybody was there? And I don't know. I just, to take this out, feels right now more like kicking the can down the road. I don't know that we're addressing the real issue here. What is it that is hearing material, true hearing material, versus what do we have already in not only our procedures, but what's in the law and what is defined as acting in the best interest of, or not acting in the best interest of. So I'm having a hard time, and I have been since,
Perhaps that's-
Board Member
about
Durham.
what is a contract, what is a hearing about contract development versus a hearing about the merits of a charter school and its operations with its district.
I think we're, and council can correct me if I'm wrong, but I think what happened is that there was an initial dispute over the imposition of a contractual, of the unilateral imposition of the 5 years in the contract, and that was a unilateral, non-negotiable position by the district. Because of the delays that the parties agreed to, which it's not our fault that the attorneys involved agreed to that. By the time I think it got to us, I think it was in the form of a charter appeal rather than a unilateral imposition, I believe. So had it been brought to us in a timely fashion, we would have been resolving the issue of was it an unreasonable imposition of a unilateral position. But because of the timing that we ended up with essentially the wrong issue for the format we were in for all practical purposes. And for whatever reason, and my memory is a little foggy on why we decided not to have a hearing, in part because it was such a long way for everybody to come. The day before the hearing was scheduled, I think it was the day before, we decided that they didn't need to come because that one issue was narrow enough. And I think it was apparent that the district was going to be sustained on that issue based on the briefs. Had we gone through with the hearing, I think we would have likely learned information that might have resulted in a different outcome. As I said, I think I voted for that no hearing, as did everyone else present in the meeting, which turned out to be, as I said, a serious mistake, and clearly I failed in my duties to provide an opportunity for the parties to be heard, as did the rest of the board, based on the briefing materials. Because the simple fact of the matter is that that provision imposes an enormous expense on a district because of the interest rates that you can achieve if you have a legal 20-year life as opposed to a legal 5-year life. And maybe there are people who think it's a good idea that paying New York bond houses more interest is a good thing to do with Colorado taxpayer money. I don't happen to be one of those folks. So we made a mistake, but there's no remedy for it because the district isn't going to reopen it, because there's certainly no penalty that district faces. The district, I believe, is hostile to charter schools. So they're just as happy that they're not going to have to face a couple $1 million of meaningful competition. So we got an all-around bad result with even the idea that you don't have to have a hearing, because I don't think you can predict in advance what you know and what you don't know. So, as I said, I take my share of responsibility. I'm not a bit happy about it. I believe, and I know I made a mistake, I believe the board as a whole made a mistake. But there's no reason to compound the felony by suggesting that this is a good policy.
That the proposal is good.
That the proposal is good policy.
Thank you.
So
All right.
are we fine with taking that out? That's Mr. Durham's recommendation.
Well, I think, Madam Chair, I think we ought to do it by motion, and and when we get ready for consideration, I have several motions I'd like to make,
Okay.
but,
All right, let me wrap up my portion of this then. The final section is section G, and this is just codifying what's already in practice, which is saying that we don't allow public comment. Because we do get some questions about that, I have in here a sentence that states why we don't take public comment. And then we also clarify that if you want to try to move for permission to file an amicus brief, a friend of the court brief, we're happy to entertain such motions. This is designed just to clarify existing practice, and nobody's ever tried to file an amicus brief. That's all I have in terms of presenting to you what's in here.
Thank you. Colleagues, questions? Mr. Durham, you want to make a motion?
well, I'll
Since you
make,
have some.
I will move to strike the new language on we can proceed without a hearing. That everybody's entitled to a hearing, I think that's basic fairness.
Madam Chair. Would it be?
We don't have the big motion on the floor
That's what I
yet.
was gonna say, would it be better to put the motion on the table to consider the changes?
That's
And
the,
you could amend.
that's absolutely the correct
Substitute
procedure.
and amend or what?
Yeah.
Board
Start
members, if
over.
I could interrupt real quick,
Please.
we are here again today as an information item, not a
Oh.
voting item.
Ah.
So,
Oh, so
I just
maybe-
need your guidance, and we'll vote on this next month, or never.
So maybe we don't.
Thank you.
Maybe the guidance is take it out, and and we don't have to have
Yep.
it in a motion. Are there other suggestions, Mr. Durham, that you had?
I have a couple of other suggestions. One is, I think that Dr. Flores' point, or Ms. McClellan's point, I forget which, that the parties should be allowed to make a presentation without interruption is not a bad idea. But the problem with the time frames is it's 10 minutes and there's no rebuttal. So I believe that those time frames should be 10 minutes initially and 5 minutes for rebuttal. They can always reserve time. I think I want them to be able to reserve 5 minutes, and 10 minutes is too short if you're going to break it up, I think.
So as drafted, we've moved it into the normal, or I've attempted to move it into the normal procedure where the first party, which in this case is usually the school, almost always the school, gets to reserve some amount of its time for rebuttal. For a 10-minute presentation, almost every attorney I know would reserve either 2 or 3 minutes for the rebuttal, and so go 7 or 8 at first. Your current procedures allow both sides to reserve rebuttals, so you do back and forth and back and forth, however you want it.
So it's not what I'm seeing here. What am I missing?
It should be under section F, it should say, yeah, under section F, line item 3 is the appellant shall present any rebuttal for which it reserved time. So whatever came out of, whatever it reserved at number 1.
Well, I don't think the 10 minutes is adequate. So I think it ought to be at least 15 for each side, total of 30. They currently have an hour. And then we'll get to the other questions.
Colleagues, yes?
No, just wanted to make a statement.
Fast. I just got a note.
Yeah, I always am fast, yes. I mean, you always ask me to be fast. I was just thinking about, I don't know, just a statement that we could pull out to tell people it's official that we can't talk to them. I don't know, it would be like a badge or, not a badge, it could be paper, but just, look guys, this is the law, I can't talk to you on this, instead of going and arguing and I can't talk to you, and making the person feel like I'm being rude or whatever, but just a little statement. Somebody,
You want this in
Governor
the charter,
Polis.
you want this in the charter?
no,
rules?
no,
Okay,
no.
in that case, we
No.
have a time concern, so that's something we
Right,
can talk about,
right.
but maybe,
Just like Governor Polis used to wear his robe. I'm not saying that we should wear a robe, but just a little statement that's
We're-
legal, that we can pull out and say.
I'll be happy to work on one for you.
Thank you so very much, that's it. No, and
So
it doesn't
guide-
have to be in here.
guidance to Mr. Peters regarding the notes. Mr. Durham has suggested that we expand the time from 10 minutes per side to 15.
Mhm.
Are we agreed? We're not voting, but
I'm
I
fine
think
with
that
that.
looks like good.
As long as it's uninterrupted.
Yes, I
But
understand.
I want
Should we
that
then,
emphasized.
Yeah,
should we then shorten the questioning time in
No.
order to keep this to an hour? Because
No.
now it's
No.
gonna be 30 plus 42, so that's an hour and 12, I think.
I can live with it, considering how long it gets sometimes. It's okay.
mhm.
We won't always use our 6 minutes either,
Okay.
right?
What about the other draft amendments that I circulated about limiting the record, asking the parties to agree on what they can remove, explaining to them that we might not read it if you don't cite it? Those are okay?
Mr. Durham?
Yeah, I think I'm okay with those, as long as it's purely suggestive, and I think that's appropriate since they don't control
Yeah.
what makes the record as long as it is. But I think from Ms. McClellan's perspective, you may not like you may not like someone asking a lot of questions during the presentation time. But let's suppose you might have 2 or 3 questions you want to ask of a couple of the witnesses. And let's just suppose for the sake of argument that one of those witnesses is clever enough to take up all 6 minutes. I think that's worth thinking about, because I promise you, if I were a witness and I wanted to limit the questions, I promise you, you'd get one. And I suspect there are plenty of smart people who are going to show up here.
Board Member McLeod.
Yeah. I think in the past, more than one of us has said, thank you, that's all I needed, and cut off a witness that we were questioning. I think we've done that before, and I don't think we're limited in our ability to do that in the future. Mr. Peters, is there a limitation for us cutting a witness off and saying, thank you, I've got my answer, I'm moving on?
Legally, you can do that as aggressively as you like.
Oh, great. Well, I'll make an effort to be polite nevertheless. But I did want to mention, for the benefit of my colleagues, although what Mr. Peters has drafted doesn't limit us with respect to whether or not we require one another to use all of our 6 minutes at one time or to break it up, it occurs to me that if we allow for that 6 minutes to be broken up in order to retain the ability to ask an intelligent question that comes up throughout the course of the discussion, that gives each and every one of us an incentive to be brief. And so I would just throw that out there for your consideration. Those of us who are brief retain our ability to ask questions later, a little prize for not blathering on. So I think that's a benefit for all of us, perhaps, to consider.
But it would be nice to have it kind of timed and have the director of board kind of do it, as opposed to the chair, who sometimes is not the nicest, of people to do it.
I'll accept that.
Thank you.
Any other guidance that you need from us, please?
I think I'm pretty clear.
Thank you. Thank you very much.
Thanks, Jim.
Thanks for
Thank you.
considering my recommendations, or hearing my frustration. I'm not sure which it was.
Thank you.
Unfortunately, we're stuck with most of it, I'm afraid.
What?
We're stuck with most of the briefs, and the record is kind of what it is, unfortunately.
Yeah, we should. I'll just say this much. The record varies in some of the different appeals, and I think, for example, by having a 20-page, you don't need to come back, by having a 20-page limit on briefs, it's kind of like a 3-minute limit. You organize, et cetera. So the reason I brought this up was in the hopes that we would just sort of put a little bit of pressure on folks. Some of the stuff I read this time was really the Department of Redundancy Department, over and over again. And so any kind of incentive that we can provide, because it feels like there's such overwhelming information that we're not encouraged to look at the record. And I find that frustrating, because I do want to inform myself as much as I can of what the various issues, particularly when there's a dispute about the facts.
So your current policies are 20-page limits for the opening,
Just the briefs.
answer, and reply, right?
I don't
And
even
then-
want, no, exactly, but I don't even want to think about what the briefs would look like did we not have those limits.
So
very honestly.
I've reduced it to 20, 20, and 15 on the reply brief. Are those appropriate
Oh,
numbers?
yeah, we forgot to respond to that. I'm fine with that.
Okay.
I think you can say what you got to say in a whole lot less time than,
You've got 10 pages all around if you want.
let's just try this. Thank you. Quick 2-minute break, 3-minute break. I believe we have a hearing coming up at 10:15.
I tried to keep it short.
Thank you.
Sorry.
Board of Education will now conduct a hearing in case number 19-CS-07, the appeal of John Dewey Institute versus Douglas County School District. During this hearing, the board is acting in its capacity to hear appeals of charter schools and will hold an appellate hearing under the relevant Charter School Appeal Law 22-30.5-108. I'd like to ask the person chosen to represent each party to enter their name in the record along with the party they represent. Please also introduce the persons you've designated to answer questions of board members. Only those individuals identified by the parties have the opportunity to address the board.
Good morning. My name's Peter Mark Johnson, and I go by Pete, and I represent John Dewey Institute. Next to me is Ms. Judy Brandberg, and she's a founding member of John Dewey Institute Board of Directors. She has a master's in curriculum instruction and science from UCCS.
Names will be
Her name's
sufficient.
And next to me is Jack Robinson, and he's also an attorney.
Thank you. Mr. Hood?
Good morning, Elliot Hood on behalf of the school district. To my right is David Ray, who's the president of the school board. To his right is Scott Smith, who is the CFO of the district. And to his right is Danny Windsor, who is the director of choice programming for the district.
Thank you. The role of the state board is to consider only those issues raised in the notice of appeal. The board has been provided with a record on appeal. References to documents or testimony not present in the record of appeal will not be considered by the board. In relation to those issues contained in the notice of appeal, the board will apply the following standard of review following oral argument. The board will decide whether John Dewey Institute, as the appellant, has demonstrated that the condition in its appealing is contrary to the best interests of the People's School District or the community. Parties have already submitted written arguments and information. Maximum number of 30 minutes will be granted for the oral argument and examination of each party's issues. You may reserve a portion of the 30 minutes for your rebuttal. During this time, the party may summarize its written arguments and information to the board members' questions. The hearing shall proceed as follows. Dewey Institute, the appellant, shall present its arguments, including questions from state board members. Douglas County School District, the appellee, shall present its arguments, including questions from the state board. The appellant, John Dewey Institute, shall present its rebuttal. The state board may continue to ask questions, and the appellee, Douglas County School District, shall present its rebuttals. The state board may ask questions. Then, the state board shall deliberate and render its decision. We will adhere to a maximum time limit. Each segment will be timed. You'll be notified by Ms. Miranda when you have 5 minutes remaining in your allotted time. So John Dewey Institute, you may reserve some of your 30 minutes for your rebuttal. Do you wish to do so, and how much time do you wish to reserve?
Yes, we do 10 minutes.
10 minutes. And Douglas County? School
The same, 10
10
minutes.
10 minutes each. And I don't see Miss Miranda. That's sneaky. As is customary with any oral argument in the administrative hearing or judicial proceedings, we anticipate that board members may have questions and they may interrupt counsel during these questions. This is the only time during the hearing when state board members may question the parties. Board questions and your responses are included in your 30-minute time, maximum time. Are there any questions?
No.
Board members? Okay. We'll now call on John Dewey Institute for the allotted 20 minutes for their initial presentation.
Good morning. Thank you for hearing us. My name is Jack Robinson, and as Mr. Johnson indicated, I'm an attorney. I've represented parents and with their children with disabilities for over 25 years now. And the main reason why I'm here is because, you know, the John Dewey Institute, their mission and their vision feels a need of critical importance to children with disabilities that is wholly and completely unmet in Colorado to date. And something like the John Dewey Institute is critically needed, and there has to be a way to find out how to put that into place. Just a little bit by way of background, as many of you know, but a refresher never hurts, is special education relates to the procedural and substantive rights guaranteed by the Individuals with Disabilities Education Act. School districts and the overarching requirements of the IDEA is to provide every child with a disability, regardless of the severity of that disability, a free, appropriate public education in the least restrictive environment. That's federally mandated, and it's mandated by the Colorado Exceptional Children's Education Act. Least restrictive environment is, basically to the maximum extent appropriate that children with disabilities are educated with their non-disabled peers. And I can tell you from, based upon my over 2 decades of experience, the most prevalent legal special education dispute is over educational placement. That is the provision of an education to children with disabilities in a school. And again, the fundamental tension is that educational placement. And the John Dewey Institute fills that need. And just by way of example, I was the attorney for the family in Andrew F. versus Douglas County School District, which is the most significant educational placement decision in the history of the IDEA. And the whole case was about educational placement. And it was about Douglas County School District's inability to provide the services and supports necessary for Drew, who was a young boy with autism, and the parents were required to find another educational placement for their child, and it happened to be a private school. And the dispute really centered around, and this is of significance to JDI's charter, is that the school district took the position in that case that our obligations to this child was to provide him merely more than de minimis educational benefit. The parents believed that Drew needed much more than that. He needed services and supports that the school district either didn't have or just simply refused to provide to him. And so they found those services and supports in another educational placement, and they sort of sued under the IDEA to require the school district either to provide those, what that educational placement can provide, or to pay for that private school. And what the Supreme Court did was said that this standard the school district was relying upon to provide Drew an education, merely more than de minimis benefit, doesn't provide a child with a disability an education at all. And they established a markedly more demanding standard. And not only Douglas County School District, but every school district in the country now has to adhere to that standard. And what is significant is that, so, I mean, the John Dewey Institute, serves a need, or will serve a need for children with disabilities that does not exist now. It's an inclusive environment with children with autism. High functioning autism is the sort of target population. That would be 50%, and neurotypical peers, non-disabled peers would be 50%. And again, I can tell you just with regard to educational placements, children with high functioning autism is probably the most complex, the most difficult population to educate, because they have average to above average intelligence, but they have these symptoms of autism that really provide significant barriers for them to access education. And school districts typically just do not know what to do with that population of students. They either perceive them as being obstinate or lazy or just difficult to manage because they have the intellectual capability to excel, but they have social, communication, and behavioral challenges that prevent them from accessing education in a typical public school setting. So more often than not, they are segregated by themselves with a peer population that's not like them, or more often than not, they're placed in private schools because the public school cannot provide them an education. That's what happened in the Andrew F. case. And the costs of that, not including transportation, which is a substantial cost as well, but the cost, say, of a Firefly, a private school for children with autism, is upwards of $70,000. And that doesn't include speech therapy, occupational therapy. And so it is a benefit, John Dewey Institute is a benefit not only to the student population, but is a significant benefit to the school district as well, because it provides a public school inclusive educational option that the school district is just not set up right now anyway to deal with. And it would save school districts, not only Douglas County School District here, but contiguous school districts, an enormous amount of money by giving a very viable, inclusive educational option that they just simply don't have. So the school district benefits saving money, the student population certainly benefits, and obviously the community would substantially benefit as well, because these children become productive members of society, that they'd be educated along their neurotypical peers, their neighborhood friends, and the typical children would benefit, the children with autism would benefit, and the community as a whole in the outcome would benefit as well.
Describe for me that inclusive
So right,
demographic.
Yeah, I'm sorry. In the application, the target population is 50% children on the autism spectrum, 50% typical peers. There's also
What are typical peers?
So typical peers would be a child without a disability, a child without an IEP.
And from your list of interested enrollees, how many of them do not have are not on the autism spectrum?
I would say right now about 20%, and we're going to really market our school more to the neurotypical.
And how do you
How do we do
market?
that? Because my husband and I, who were the founders of the STEM school in Highlands Ranch, and we were the people that had the initiative and the vision originally for a project-based school with these research labs, hands-on curriculum with science, technology, engineering, math, which works really great for students that are on the spectrum. So we need the charter approval in order to go forth and get
I'm just trying to I have a hard time figuring out parents that would commit their kids to a school that is 50% on the autism spectrum, and I would like to know what is it that you're offering them that they would not get in another STEM school in Douglas County, for example.
They will get the opportunity to learn to be tolerant and kind and inclusive.
Okay, thank you.
And those are core values that we're going to really stress.
Okay, thank you.
But I think, to answer your question as well, is that, I'm on the board of charter school in Aurora Public Schools, Vanguard Classical School, whose mission, whose vision is the inclusive education of children with disabilities and children without disabilities. And it's a wildly popular school, one of which is because, children with disabilities have siblings, and that parents want their child, and the first, critical importance to parents is addressing the needs of their child with a disability, who's most difficult to place and to get an appropriate education. And they are very active in finding out what is the best opportunity for their child. And invariably, the siblings will follow the child whose need is being met. And so there is that need for, the family unit to be together. Whereas in another situation is the child is sent off to a private school or is sent to a school without their siblings. But that is just one example. There is, tons of research out there too that demonstrates that children without disabilities, typical children, greatly benefit educationally by being educated alongside children with disabilities. And two, we're talking the target population is children on the high functioning autism scale, who invariably, to go back to your ratio of students, really the autism, say population would probably be 15% twice exceptional children, 15% children with average to above average intelligence.
Would it be legal for you to turn away an autistic child that were at the very severe
No,
end of the spectrum?
no, and
Are you not likely to receive applications?
Sure. In the application, and maybe Ms. Brandberg can speak to that in more detail, the application or it is gonna provide the support and services for more severely impacted children with autism. And so certainly all children, you know, whose needs can be met at that charter school will be provided in a free appropriate public education. I think the target audience, here's who we're marketing would be typical and specifically children with autism, which again, as I said at the outset, it's a need out there. It is, I deal with it all the time, and it's an unmet need, and it is a major struggle.
Mr. Robinson, would the autistic children be damaged in some fashion if you didn't meet the target? Let's say you had 70-30 or 80-20. Would there necessarily be any harm done to the autistic children when they're part of that 70-30 mix, 70% autistic, 30%
No.
not on the spectrum?
Yeah, no, I mean, that's a good question. I don't think, you know, I'm not an educator, but I don't think the mix is as important as, you know, this notion that again, Ms. Brandberg can talk about the sort of the teaching philosophy, but what's important here is that the teachers and the support staff are gonna be specially trained in addressing the needs of children on the autism spectrum, which is gonna benefit, you know, the typical children as well. But that is, you know, one of the reasons why it's so difficult to say educate this population, is that they have unique challenges that are sometimes hidden. And it takes an experienced, well-trained teacher to address those needs, keep them included in the regular education classroom, as opposed to, again, the default being, let's ship them off, let's send them to private school, you know, they can handle them, they're specially trained to handle them, we'll write the check, we'll send them on the bus, or, you know, we'll separate them out into a self-contained classroom.
One of the concerns that was expressed, I believe, is that there are not enough special education teachers. Parapros, while they can be trained, there's a very high turnover because they're very poorly paid.
Yeah.
And a school with half the kids on the spectrum, some perhaps severe. Is there a formula that's required by law? How many special education teachers? Because I think this definitely addresses your budget issues.
Yeah.
But it's a high cost.
Do you want to go ahead and start?
Mr. Johnson, go ahead.
Yes, as you know, we submitted a budget with our reply brief, which was submitted merely as an offer of proof to show that it can be done. And in that budget, and if it's remanded, that would be submitted to the board. We've revised to have one special education teacher and to manage an IEP caseload of 25 students, which means we've found a way to make the money work to have 7.5 special education teachers. As the school grows, we'd like to hire more of them. We'd like to hire 3 or 4 more, depending on the mix of the students and the needs of the students. We'd also like to bring in initially one speech language pathologist with a plan to bring on 2 plus a special speech language pathologist assistant if we can get additional funding. We'd also like to bring in at least one OT, occupational therapist, physical therapist with more as the school grows, and one mental health provider with possibly more, as well as an English language development teacher, 12 and a half education assistants.
How many students do you need to have in your program to be able to afford your wish list?
Our budget would be 188 neurotypical students and 188 ASD students in their least restrictive environment. Now, one of the problems we've had, and I spent a significant amount of time in our brief discussing this, is the template that the board provided for us doesn't designate how much money the school board gets for disabled students. So we have guessed the amount, but we know there's approximately,
$3,100.
31
Administrative units.
3,100 administrative units. But it never informed us about funding under other federal funding, IDEA funding. So we don't actually know how much money the district actually gets. And that's, I'd love to have that information.
Actually, I think the district would love to know what it gets each year. This is a moving target for everyone, not just for what you're looking at.
Well, the last data we had was from 2011, 2012, and I'm sure that,
No.
or 2000, I'm sorry.
Last year, we heard Mr. Durham say that when you asked staff, it was $11,100 for fiscal year 16-17.
So we're 2 years behind the scale on that.
Your budget is based on 188. What if it turns out to be 300 and,
Well, if it's 300, you're talking 300 students on the spectrum, or 300, okay.
on the spectrum? I mean, we
well-
just talked about the possibility that 20% might turn out to be the best.
Well, my understanding is that we'd be getting more money in the event we had a higher number of students on the spectrum.
Yes, but does that match the need that you would have? You would need more special education
Yes.
teachers.
Yes.
You would,
Yes, if we had more money, we could obviously hire people quicker.
yeah.
And I would say, it says that the ratio of children on the spectrum, say, or children with IEPs is not gonna be directly proportionate to the number of special education teachers you need. I think the fundamental there's gonna be general education teachers, and depending on the needs of the child, the majority of those children with autism are gonna be in a regular education classroom with a regular education teacher supported by a special education teacher. And speaking of the funding too, just real quick, is the ECEA does recognize the challenges of educating a child with autism, indicating that all children with an IEP get X amount, 2,000 some odd dollars. Children specifically with autism and other complex needs are allotted an extra, I can't remember, up to $6,000 or whatever per child with an IEP with autism. And that money should flow to the John Dewey Institute on top of the per pupil funding allotment.
If in fact the district has that much money per student, because they're still going to have autistic students. There will be parents who
Right.
will not seek your school.
Right.
So it'll be sort of a need to share those extra funds,
Right.
as I understand it.
And that would be, yes, that would be worked out through the contract, obviously, but if the charter school is going to be providing that free appropriate public education, there's an administrative cost, obviously, from the school district, but if the charter school is going to be implementing that IEP and providing those services and supports, logically, the funding for doing that would flow to the charter school.
Go ahead.
The rest of you.
Board Member Flores.
I know you keep saying that, that parents who have kids that are not autistic would not want their kids to be, why
Please,
would they?
this
You
is-
asked the
this is
question.
This is the time to speak to them, not to me.
Right, but I disagree. I think that project-based education is something that a lot of parents would want, and I think that there is a need. So, but my question to you really is, is that I wish that you had provided a curriculum. And there are curricula that are out there, and I think it would have helped your case very much if you had provided that. And usually, when presenting to a school district, and I was on the SEAC committee for Denver Public Schools, that is a must. You can't just you know, say, well, no, we're thinking about it and we have other issues. So it is important.
So we did provide a curriculum. It's in the, it was in our record on appeal. We're gonna follow the state standards. We're also gonna give kids on the spectrum unlimited time and to finish each
I didn't see it.
class. That curriculum, we were only given 125 pages to write the charter, so those were in the appendices.
Thank you.
Okay.
Mr. Hood?
Morning. Let me first start by answering a question that was posed to me by Mr. Johnson, which is, you know, we'd love to know how much money the district received last year in ECEA Tier A and B funding. It's on page 14 of our answer brief. It's $12 million out of the $93 million that we are budgeted to spend on special ed this year. So it's there. I want to just kind of address some high-level points here that I heard from JDI. One is no one in the district questions their intent. Everybody recognizes that they have a really solid goal. Their vision is admirable. The problem is that they have not proposed a school with a realistic view of the budget and staffing needs this will require. We heard a lot about Andrew F. We didn't hear a lot about the school. Andrew F. has nothing to do with this case. The only thing it has to do with this case is that it provides the governing standard for what a free, appropriate public education is. And I can tell you that I've read this application a bunch of times and I've read their unsolicited and solicited information. Andrew himself would not be able to be served by this school. Andrew is at a school called Firefly that is a more of a clinical setting. It is not a CDE approved facility school, and it caters to students with severe needs who hopefully can transition back into a regular school. But this school is not outfitted at all or even envisioned appropriately to serve a student like Andrew. So I just want to make that clear. I think this really comes down to they've got an interesting vision for the school. Would it meet a need in the district to have a school that was designated for kids with autism? Maybe. There are a lot of kids with autism in the district. The vast majority of them are in neighborhood or charter schools, and they're doing just fine. There are a handful of kids who are placed in out-of-district schools every year. There are 31 kids who the district places as part of the IEP process out of district every year. And they are placed in those schools because their individual needs require the types of schools that no district in the state has. Places like Firefly, Shiloh House, the Joshua School, they have very specific programming there for kids with very specific and severe needs. And it is really not comparable to talk about the proposed school we're talking about here and those schools. And the fact that we do place kids out of district in those schools does not mean that there is a demand that they're going to meet. We actually have our own school called Plum Creek that if you're familiar with Sebesky Academy in Jeffco. Plum Creek is a school that where we place 40 to 50 kids every year who have a variety of disabilities. Many have autism, but some don't have autism. They have other disabilities too. And we're serving those kids well at that school. So the idea that there is a demand out there for this school among families who have kids with autism is just not borne out by the data they have provided or the arguments they have made. Unfortunately, this just comes down to the numbers don't add up. They just don't. We have gotten 3 different budgets from this school. None of them work. None. The first budget they admitted doesn't work. The second budget, which they submitted to us a few days before the board meeting, identified what they termed to be a new source of funding. Well, we could talk about whether that funding is available to the school directly as pass-through. But even if it was, the numbers don't add up. In that revised budget, they put all of that new money into facility costs. Now, keep in mind, the facility that they have envisioned is really cool. It's got a lot of bells and whistles. They want to have individual robots for every kid. They want to have aviation labs, artificial intelligence labs. A STEM-based school requires a ton of technology. They identified some funding that they believe they can get that will be able to pay for that. It's not even close. Not even close. And even if it was, they haven't in that budget proposed a proper staff structure to accommodate appropriately kids with autism spectrum disorder, who are, as Mr. Robinson said, some of the most complicated kids that we serve in school districts, no doubt. They still proposed in that revised budget 1 special ed teacher for 200 proposed kids with autism. Now, they have since changed those staffing numbers. However, I think that the fact that they proposed 1 special ed teacher who, by law, must be the person who's providing special ed minutes for a school of 200 shows that I'm not even sure they know what they're doing. Our special education staff looked at this and were appalled. There are just serious gaps in just knowledge, basic knowledge about what it takes to serve kids appropriately with special needs. And I can tell you, I spend a lot of time defending school districts in cases where everything goes right, where the school district is fully set up and schools have the right staff, they have the right budget, they have everything in place. And sometimes there's a disagreement between the families and the school, and they spend a year in very costly litigation. Just imagine if the school isn't set up for success. The final budget they proposed, unfortunately, also doesn't work. They have proposed a staffing structure this time with the new funding that can appropriately be spent on staffing and not facilities. There are some problems with that staffing structure, but I think the main thing is they're just robbing Peter to pay Paul. They took the money they were going to put into their facility leasing and they put it into staffing. So if you look at their third budget, you'll see that the budget for facilities is drained to accommodate the staffing structure that we pointed out that they needed in our answer brief. This isn't information that they determined on their own. We told them repeatedly why their school wouldn't work. We told them repeatedly during the application process why it wouldn't work. To their credit, they have revised their proposal every time. But you know what? This appeal process is not for revising your application. This appeal process is to determine whether the local board made the wrong decision in saying no to a school, not a chance to fix your application. So I think that we just need to take a serious look back and think, okay, is this school really going to appropriately serve the kids that they are assuming are going to be their target population? And any which way you look at this school, regardless of the vision or the intent of the folks who are proposing it, it just doesn't work. But I want to pass it to Mr. Smith to make a few comments about the funding.
I want to ask Mr. Ray a few questions if I can. So, Mr. Ray, your per pupil, total per pupil revenue, state and local shares, at least $11,000 plus. Do you share any of your local share with charters?
I'm going to refer to our CFO just because he's got the exact figures, so I would,
Okay.
Mr. Smith?
Mr. Durham, yes, we do. Excuse me, we share 100% of the per pupil revenue and 100% of our local mill levy override. We also take into account ECEA and IDEA funds. We work on an insurance model with our charter schools as it relates to high-cost special education, and those revenue sources are netted out against the costs that our charters pay to that insurance model. So while they're not receiving the dollars directly, they are receiving the dollars indirectly because it lowers the amount of unreimbursed special education costs that our charters are paying. So if we were to start passing those dollars through, the end effect would be our other charter schools would pay more for their special education services that the district is providing because there would be less revenue to net against the cost that the district is incurring. And my belief is our cost of educating all of our high-need special education students wouldn't change very much if the school were to be approved.
There's a district in Colorado Springs that has opened a district-run charter for dyslexic children that seems to be getting a very good result. It's of course open to anyone, but I think I'm not aware that there are any other than dyslexic children in the school. It costs the district more than the average per pupil expenditure, but by essentially having a school that specializes, it would appear that they might be getting a better result than they're getting in other classrooms. Parents are clamoring, they have a waiting list to get in. Does that kind of concept, Mr. Ray, make any sense to you, to experiment with something like that?
Well, certainly, we have center-based programming in our district already with a similar concept, where we can really make sure that we pool our resources together for students with a certain profile or certain need, and we have found success with that as well. I think as far as do we need to have that program housed under its own roof, I would probably have a compelling argument to say that I would question that. But certainly, we have explored that opportunity as well, as whether or not we might look more at a magnet-type approach to an innovative school of that nature.
Could you cite the board reasons for rejecting the school for me, please?
I think you've heard them. Basically,
I want to know specifically what the board,
sure,
in a majority action, cited as justifications for its reason.
Sure. We certainly, the themes that we were concerned about included programming and as well as budget.
And those were expressed in a resolution?
In a motion, indeed. So in our motion
So a motion, so the motion included then pages of reasons why you were voting no?
The motion included statements from each board director explaining why they were voting the way they did.
So each board member then explained their vote.
Correct, which was also documented.
You are
in our
aware
minutes.
that that is not a collective result. You are aware that in a legislative committee or in the General Assembly, Senator Foghorn and his colleagues may all express their reason for voting for a bill, but none of those individual expressions constitute the intent of the legislature. And I think that's true of a board, and it would be very helpful for all of the parties if there were a resolution explicitly stating and including all of those things that the board agreed on by majority vote. Because otherwise, as a practical matter, the fact that each individual member may have expressed a reason is interesting, but of no legal consequence, and it makes it extremely difficult for the responding party to try and rebut any of the contentions of the board. And it makes the job of this board difficult because we can't analyze the responses to each of the individual questions. So I think there's some question about whether or not it's absolutely legally required that a board act by resolution, but it is certainly by custom. I don't think I've seen Mr. Elliott here before with a board that didn't act through resolution. So is there a reason that you ignored Mr. Elliott's advice and didn't have a board resolution?
Mr. Elliott has not given us that advice, number one. Number two, we follow the direction of our legal counsel, and our legal counsel did not see at that time a need for a written resolution and felt that her interpretation of the statute did indeed meet the criteria by our action. If that's an area that we need to improve, absolutely, we are open to looking at that.
Well, Mr. Elliott, most of your clients do bring us a resolution, don't they?
Yes. I will just note that the last time I was here with the same founders, which seems like a while ago, probably a year and a half ago, there was no written resolution there as well, and that was not an issue at that time. But your comments are well taken.
Thank you.
Mr. Smith, can you give us basic information about the number of special needs students in your district? How many are on the autism spectrum? What percentage are on the autism spectrum?
I can actually.
Oh, sorry.
Yeah. So the big numbers are there are 7,300 kids in the district with IEPs, individualized education programs, which is special ed related services under the IDEA.
About 12%? About 12%?
Of the 67,000 kids that we have.
A little more
Does
now.
anybody have a
Okay.
calculator?
No, it's okay.
Yeah, it's about 12%.
It's closer.
632 of those kids have a primary disability of ASD or autism spectrum disorder. There are currently 400 of the kids who, of the 632 that I just mentioned, are in what's called an LRE or a least restrictive environmental setting of at least 80% in the gen ed setting, which means that they have mild to moderate needs. And then of the 632 students with autism as a primary disability, 230 are in center-based programs, or they are placed in schools for students like we were just discussing earlier who have more significant needs. That's about 36% of kids with ASD in the district who have been identified with an educational diagnosis of ASD, meaning they have IEPs. I want to be clear, though, that there are lots of kids in every district who have ASD, a clinical diagnosis of ASD, who do not have an IEP because they have autism spectrum disorder, but they don't require special education and related services to access their curriculum. They have typically what's called a 504 plan or other kind of accommodation plan where they are given accommodations to help access the curriculum, but they don't require specialized instruction.
Thank you. Board Member Schaffel.
Can you speak to the extent to which project-based learning opportunities are available for those students or others in Douglas County?
Sure.
I think you'll see a lot of different project-based learning opportunities throughout our schools, whether that's elementary or secondaries. And as far as an exact number, that's there. I don't have an exact number for you. However, I know we have a number of folks who have received training from the Buck Institute, in particular around project-based learning, in a variety of areas as well.
And the STEM school is, of course, one example of that.
Montessori, do you have Montessori?
Yes, we do.
Montessori, yes.
Yeah.
Board Member Goff.
Thank you. Two quick ones, I hope. You mentioned quite a bit about twice exceptional, and I guess maybe a tiny bit of detail around teachers. Teachers conducting any twice exceptional activities, classes, students, project-based learning, whatever. Is there a specific spot for GT specific direction? I'm sorry. I know this is the district's time, but even your
Our time's up,
interpretation.
so.
Currently in the district would be of help to me to know as well what the, as far as.
I can't see. This is not working for us.
Time isn't up yet, 2 minutes and 30 seconds.
Oh,
Okay.
okay.
Sorry.
What's not working?
We
The fact that I
can't see the
see.
timer.
Not working for you?
You can see because you're over there, ma'am.
I can get used to this. Sorry. Twice exceptional GT specific question. The other one is, as far as CTE, the whole workforce development focus on, in Douglas County, how that's, what's the status of that? Do you feel good about the ongoing outcomes for kids on that? And actually, where are special education students in general, particularly those with autism, how are they faring under those kinds of programs?
I think that's a great question. As far as specifics with the ASD designation, we have to pull information on that. However, we do have 94 approved CTE programs that are within our district, and actually have just reinvested $15 million actually into pathway programming specifically for concurrent enrollment CTE and creating greater access and opportunity regionally for each of our students as well. So we are working with principals actually right now in developing particular CTE pathways for our kids all students. It's actually written into our strategic plan that we're just finalizing as well, about looking at that disaggregated data to make sure we meet the needs of all students and not just pockets of students. As far as your question about the twice exceptional component in GT, that actually was one of our questions we had, that there was really no mention of ALPs actually in the plan as well too, and about how to implement that. It was just talking about that we'll be in compliance, and there's a difference of talking about that we're gonna meet those needs, but actually implementing and how to do it is what was not described.
Okay, thank you.
Mr. Ray, how long have you been on the board?
I'm completing my 4th year.
And how many charter school applications have you had in the last 4 years?
The last 4 years, I would say we've had 5.
How many of those have you granted?
We've granted 3.
Thank you.
And I'd like to, can I add? Okay, not yet.
Just one more point before our time runs out. There have been some questions about the non-ASD kids who would be attending this school. I just want to mention that the major gap for us in that formula that they proposed is that there was really no programming at all proposed in their application for traditional students, kids without ASD. That's really the main problem.
Thank you.
I still don't know what it looks like.
You have 10 minutes, please, for your rebuttal.
I'd like to address several concerns. First, I'd like to talk about Mr. Durham's concern. The procedure that was followed in denying this application makes no sense. They didn't follow the state statutes, and they also didn't even follow their own handbooks. I've got 3 of their handbooks here, and they have changed deadlines. They've said one handbook applied when another applied. So I don't really know what procedure, what's legal support they have for that procedure. I mean, it seems to me to be a case of bad procedure making a tough result. And from the tone of everyone's questions, I believe that had the board communicated, we might not be here. But by not providing a resolution, by not properly notifying the board, by not including the minutes of the board meeting in their record for approval, by not holding community meetings with applicant presentations, by failing to communicate even the existence of additional funding in their budget template, and then by specifically requesting information and then not considering it in their meetings, that this procedure absolutely failed. Now, the statute doesn't provide a penalty.
Do their procedures, their own internal procedures suggest, or state law suggests, they should have a hearing or some public, what would amount to a hearing on the
Yes.
application?
Yes,
Did they have such a hearing?
No.
Thank you.
And then I know one of the board members even made a specific statement that he promised not to override or overrule any staff CART recommendations. Now, due process presupposes following procedures, that everybody gets the same procedure, but it also presupposes a neutral and detached hearing for that procedure, and at least in this one person, it didn't happen. And the neutral detached magistrate, but the others, they just, like I said, they made this up. Now, I'm not here to say these people are categorically unfair, but in this case, the procedure that they followed doesn't relate to anything. They made it up. As you can see in the briefs, they changed deadlines, they asked for information, didn't hear it. They really, they made this up, and by not following the proper procedures, I think in fairness, JDI deserves another shot.
I'm going to try to answer as many questions that came up. First of all, I love David Ray. He was my 3 sons' principal. He's the best principal ever. But he doesn't like charters, and he hasn't voted to approve any charters since he's been there. And so that's the first thing. Number two is that something that our school can do, which Mr. Robinson addressed, was the career in tech, the Maximus, not just a minimus. We're going to provide two substantial benefits to kids on the spectrum. Number one, a high school diploma, which most kids don't get that are on the spectrum, and number two, a career in tech education. And I spoke just a couple days ago to the director of TACT, Teaching the Autism Community Trades, and she has over 60 kids coming from Douglas County to her program. So the career and tech needs of students on the spectrum are not being attended to. Also, our application did address the advanced learning plan, the twice exceptional. In fact, yes, there were many pages about that. Also, when the board voted on June 4th, they requested specifically that we have an early childhood intervention program, and so we expanded that, and also significant support needs. We'll take as many kids as we can be funded for. So that's definitely something that we care greatly about. And I spoke with another, okay, I have a lot of things to say here, but I'm gonna go ahead and turn it over to Jack. Do you have any closing?
Yeah, I was just gonna, again, sort of end where I started with regard to the need. There is a need. In this population, the specific targeted population is not being served either in the Douglas County School District or any metro area school district. And the placement and programs that were mentioned in the school district's argument are apples and oranges. You have Plum Creek Academy, Sebeski Academy, Shiloh, Firefly, Joshua School. Those are all specifically placement and programs solely for children with disabilities. There are no typical peers, and they're solely for children with very, very significant needs. This is more akin to in the self-contained classrooms as well, which most school districts have. Those don't serve this population at all. The vast majority of kids being placed in self-contained classrooms have behavioral challenges that just can't be met in the regular education classroom, so they're being removed. But those kids in self-contained classrooms are not high-functioning children with autism. And if they are, that's not where they should be. They should be in the regular education classroom, but having their needs being met. This is much more akin to the charter school in Colorado Springs that you had mentioned with regard to children with dyslexia, which is wildly successful and has a waiting list. This is an incredible unmet need, and the school district admitted that this population is the most complicated, difficult population to educate, and it has revolving mental health concerns when these kids are not being educated to their needs. I had one other thing I was going to say, but now it's escaping me at the moment. But
That'll get worse with age.
I'm rapidly getting
And
there.
I'll just have another little comment here. 1/58 of our population has been identified as being on the spectrum, and those numbers are growing, and especially even in South Metro Denver, they say those statistics are even higher. So there is a tremendous need in Douglas County. So if there's 67,000 students, I heard 68 now this year, that would be about 1,100 kids who are our target.
You're completed, yes?
We're done.
Okay. Mr. Hood and Company,
Uh,
10 minutes?
So, certainly won't take the full 10, but just wanted to address some of the procedural issues that they've raised. One is that we made this procedure all up. I mean, reality says otherwise. Our website has featured for years a website specifically for charter applicants. There is a link on that page that says new charter applications that you can click on that I did yesterday, I did a couple weeks ago. It's got all the relevant info that you need. In fact, it had that relevant info correct, for the last year.
Well, Mr. Hood, was there a full hearing or wasn't there?
So
Did the
the-
board have a full hearing where they had witnesses and testimony? How long did it last? How many witnesses did they have? How many proponents did they have speak? How many opponents did they have speak? Could you describe that hearing?
Sure, so let me start by first saying what the Charter Schools Act says, which is that you have to have public meetings. It doesn't say in the Charter Schools Act you have to have a full-blown hearing. There were 2 public meetings on this application, a third applicant interview, which was like a 2-hour interview.
An interview conducted by whom?
The district and its CART team.
What
where
about the
they-
board? I mean, the board gets to make the
board,
decision. I
there were
mean,
2 meetings
it's
with the
my,
board.
my experience that school boards tend to over-rely on staff. So if they really want to get to the heart of an issue, they need to spend a little time at it and spend a little time in listening to points of view. And
I
did they
agree.
do that?
I agree, and that happened here. So we had
So
2
they were in the CART meetings, the board was in the CART, were you
No.
there, Mr. Ray?
No,
So-
Any of your other fellow board members in that meeting?
not in the meeting he's referring to, but as he has stated, we had 2 hearings before the dais.
How long did they last?
I'm looking at my minutes right now. We had 12 speakers at the May 14th hearing, and each speaker approximately has 3 to 5 minutes.
Any back and forth, any inquiries, any what kind of goes on here, try to achieve more information, anything like that?
Deliberation among the board always, but certainly not in terms of interacting with public commenters, no.
On June 4th, that did occur, though, an interaction between the board and the applicant.
And what was the,
They were provided an opportunity, 10 minutes to be able to present to the board, and then have 15
5.
minutes, or 5 minutes, excuse me, thank you. 5 minutes to.
and you really don't want to overdo, do you?
And then an opportunity for 15 minutes.
5 whole minutes, huh?
Well, 15 minutes for Q&A as well,
Wow.
which actually
No.
went beyond that as well.
Wow, that's really, so Mr. Ray, is the comment that you've never voted for a charter application true?
It's
It's
false.
not true. Okay.
I can list those charters that I voted for if you would like. I would
Just
also.
a number would work just fine.
Just to defend my record, every charter that has come before us requesting renewal, I have voted yes.
What about new applications?
So 5,
Yeah, I know, but how many did you vote for?
3,
So you voted for all 3 that,
correct.
okay, thank you.
The comment about we have inaccurate information online, that's simply not true. There was an error in our charter manual that actually is not specifically for new applications, but they brought it to our attention before they submitted their application. We admitted the error in the due date of the application. We changed it immediately. They were able to get their application in early regardless of that error. So to me, I'm a little unclear as to why they keep arguing that the process was unfair. They showed up for every meeting that was noticed. They turned in everything on time or early. They certainly got notice of the decision to deny the application in a timely fashion. So the idea that we made this all up and weren't following our own procedures or weren't doing something that gave them sufficient notice, I'm baffled by that, to be honest.
Mr. Hood, we have one more question.
Yes.
Board Member McKenna.
Thank you, Madam Chair. If I understood Ms. Brandberg correctly,
Yes.
I believe she stated that the career and technical needs of autism spectrum disorder students in Douglas County are not being attended to. Did I understand correctly?
There is a large population that are going, that are being bused currently to the Teaching Autism Community Trades,
Okay.
which is a program specifically designed. It's the only program of its kind in the whole United States, and it's designed specifically for students on the autism spectrum. It provides.
I didn't want to cut into their time. I
Okay.
just want to give them a chance to answer to that, because what I heard you say was that their needs were not being attended to, so I wanted to give the Douglas County side a chance to answer that.
I absolutely disagree with that 100% in the sense of the number of students that we've had complete as far as between taking 2 or more classes with CTE programming that we are aware of, and also the number of students that are participating in. We actually have been growing in our CTE programming for continuous years as far as the number of students that are accessing that. So that's completely false.
So that $50 million that I heard you indicate is being invested in CTE, if I understood correctly, is that including students with and without both high-functioning ASD students as well as perhaps students with IEPs or 504 plans? Okay, thank you.
And it's 15, not 50?
15 is the additional funding that's been reinvested this year from our bond.
15 plus 50.
No, 15.
15, I misheard, I beg your pardon. Thank you for that clarification, I appreciate it.
If there are no remaining questions, we cede our time.
Thank you. Thank you very much for your presentations. Colleagues?
Madam Chair?
Hi.
Madam,
Yes, Board Member Rankin. I forget that you were there.
Thank you.
I don't see your hand up, and so.
yes. I've been listening very carefully. I just have a couple of things that I would like to share, and especially with Mr. Robinson, and that is that in my district, I have visited some parents and at meetings with some parents of students that are autistic. Sally Bernard and Peter Bell in the Roaring Fork Valley are very, very into this. And I have to say I went in it with a little bit of trepidation, but they have created a program for what happens after 12th grade, the outcomes of education. And it made me look at it a little differently. How do we prepare these students for what goes on after 12th grade? And it sounds to me like this particular charter school is what this is all about, especially since it's project-based. I'm sure there's things in the community because this is how these students have to be integrated. And I've also looked at some of our other charters and online schools where students are not making it in our regular high school. So the fact that this is innovative might capture the attention of some parents whose students may not be autistic, that may be struggling in a regular classroom where learning about project-based experiential STEM, some other opportunities. I have a feeling this particular school would look different than any other school we have in our district. So the key, I think, is innovation. I've opened my mind to it. I'm not saying they have everything together just yet, but I'm saying their thoughts and their minds are in the right place. And I wish everything had come together so that this district would have helped them with that. And that's going to be the direction I go, that maybe they can cross the T's and dot the I's, because these students are a part of our community and will be. And I'm not quite sure how our public schools can all manage that. I wish I had the answer to that. I don't. So I'm open-minded about it. I just wanted to put that forth. Thank you.
Thank you, Board Member Rankin. Other comments, colleagues? Board Member Schaffel.
I think there's been some confusion in just talking about the type of students this school would hope to serve, whether these students are high functioning on the autistic spectrum or not. And I think what you said is you're hoping to serve those that are high functioning. You would take other students as well. But I think this project-based learning model is unique. It's been around for a long time. It's used periodically and sort of sporadically, pedagogically in schools all over the state. But it's not used pervasively and as deliberately and as consistently as you're proposing. And it can really be a huge help to high-functioning students who evidence autism and also other students, because it tries to situate learning in a context that's meaningful and applicable to real life. And that's what a lot of parents are looking for. We know that, school can be highly symbolic, highly focused on the assessments, and a lot of kids are left behind by that because of the way they learn and the way they process information and the need for authenticity and context when they're trying to master skills and content. So I guess I see this school as an addition to the kinds of pedagogical models that are already in place. And I'm sure that some of that occurs in Douglas and it occurs all over the state. But the kind of model you're proposing, I think, would be a huge asset to lots of kids, including those on the autistic spectrum and other students as well.
have a
Question?
couple of comments.
Sure.
I don't think we can ask questions anymore.
We can't ask them questions, but we can discuss it.
Yeah. I think the, notwithstanding Mr. Hood's,
And
Can you hear?
can you hear Joyce?
I'm here.
Okay. Well, I think notwithstanding some of Mr. Hood's comments, I mean, there are a number of at least claims in the briefs that procedure was not followed, and I don't specifically recall seeing most of those rebutted, but for example, Mr. Windsor is quoted as saying that there would be no community meeting for the school to present a PowerPoint. And I don't recall anybody rebutting that.
Yeah, it was rebutted.
was. It was.
It was, it's in the, well,
So there wasn't, well, never mind, we can't ask the question, whether in fact such one took place. But I think the procedure is sufficiently tainted in this case. And I think while there is a legal standard, there's really no reason for a board not to ensure, for a school board not to ensure that the parties at least feel they've had an adequate opportunity in a fair public hearing. And I think that makes a lot more sense than trying to limit in any way, or at least unless the requests are unreasonable, an opportunity for a full presentation and discussion of views. I don't get the feeling that happened, and I don't think there's any claim that in fact you went beyond the jot and tittle of the law to provide any of that. So, and I do think the failure to have a resolution is a serious problem. We've had significant discussions about that, and I think a resolution I think is required, and certainly if not required, it's certainly a lot better policy than what we have here to deal with, because there's really no standard to measure the rejection and the response to the rejections against. So, because the board did not express any specific reasons for taking the action. Some individuals did, but unless you incorporate those into a vote in which you have a majority voting for, you simply have individual expressions of concern that don't rise to the level of creating a record on which an adequate appeal can be had. So I think the procedural issues are serious. On the other side, I do think that the budget questions are real. I think there are some significant questions about budget. I do hold out some hope that this model, like the one in Colorado Springs, the district might try and be innovative enough to see if you could find a way to save the taxpayers some money. Because quite clearly, when these kids are not properly educated, it costs society a lot, and it costs the district a lot if you run into the kind of appeals that Mr. Robinson is talking about. So if you could avoid a few of those, it wouldn't take much to make up the difference. So I think that's just part of the problems that we have here. I think public education in general shows little desire to innovate, and that generally leads to increased costs, and I think it's abusive to the taxpayers not to explore possibilities that might reduce total costs.
Board Member McClellan?
Thank you, Madam Chair. I do take Mr. Durham's point that the budgetary concerns are real. I'm concerned about unrealized grant funding being necessary for this school to be a viable operation. And one of my chief concerns is that the initial application indicated one special education teacher for approximately 188 autism spectrum disorder or disabled children. So I do feel like the district has been innovative in allowing for facilities such as Plum Creek for students who have more intensive needs in their IEP or 504 plans. And and that they have invested in CTE, which does include children with a 504 plan or perhaps an IEP to successfully complete those programs. So I do think procedurally, I would like to ask our legal counsel, the procedural concerns that Mr. Durham has alluded to with respect to a proper hearing, that's not a hard requirement that Douglas County is proven to have failed to meet, is it?
So, there are certain requirements around having hearing, ruling by resolution. I think what exactly resolution means and what that looks like, there could be some debate there. I think in this case, a little more reasoning from the entire board would have probably met the law more safely. And I'll let my much smarter boss add anything she wants to.
The statute has some specific requirements in it. The hardest part is it doesn't define exactly what the consequence for noncompliance is. Certainly, it's within the board's discretion to determine whether a procedural irregularity rose to the level of potentially compromising the best interest of the community. And you'd have to tie it back again to your standard of review. And so, and that's entrusted to your discretion, exercised soundly, of course.
Yeah, I guess a part of how this comes down for me is that even if there were room for improvements in Douglas County's procedures, and we could debate that perhaps another day, but even if that were the case, that does not magically resolve the legitimate concerns raised during their review of the application. So I would not want to go forward with an application that is not in the best interest of the community simply on a technicality. So that brings us back to the concerns regarding the budget and the number of special education teachers, given that the focus is for a special population, or at least for a substantial portion of the population to be kids with autism spectrum disorders.
Does everybody
Board Member Flores.
I would like to say that, oh, sorry. But then we have that. I don't know if I can. Thank you. I do think that the John Dewey Institute's budget,
Your call cannot be
did not meet the needs of the school, and that JD did not provide details about potential co-location. But my biggest problem or issue with this was that it didn't speak directly to the various spectrums of autism and how they would be met. Also, as you pointed out, Mr. Hood, they didn't really talk about what they would do with the other children that are not on autistic spectrum. And that is, well, that is just very troubling for me. Two,
You are
I mean,
joining your conference room.
I guess
You are the
I'm
host.
at 4.
Access is immediate. For a menu of
The
available
letters were
press
not,
6
I'm going
and
to
the
put my
pound
kid
key.
in this school. That's an interesting school, it's needed, but it didn't specify, I have 4 kids that I want in that school, and I just thought they were letters of interest, but were not specifically, I'm going to place my kids here. And there were, you mentioned that you're going to have 188 kids that are on the autistic spectrum and 188 kids that are not, but yet I didn't see any evidence. And let me tell you, I did read through this, through your material, and I just didn't see what you were going to do. I mean, it was kind of nebulous and out there that you were going to do project-based, and I certainly am one to that likes that kind of school. And maybe if you worked on it and came back later with a better written, with definitely the material and information content that is needed, that I hope that Douglas County would take it up again. But at this point, I just cannot vote in favor of your project, of the John Dewey School or Institute at Douglas County. And I can see why the board did not vote for it. I'm sorry. Thank you.
Thank you. Board Member Goff, is there any comment you want to make before I get my shot?
I was just going to defer to you anyway.
I'm supposed to be last.
Yes. I will echo what Ms. McClellan said as far as questions that would still be there regardless of how the timeline or the process would have been adjusted. There should be and is, in this case for me, a lot of concern about how budget is determined, how realistic is it, how much forward thinking appears to be evident, and I'm concerned with the staffing situation as presented. I will acknowledge my agreement in the belief that that teaching and children's experience among and within an entire range of learning styles and learning classifications, what you might call it, is beneficial to everyone involved at all the way around. It's a full circle benefit to the world learning. So I would also encourage further conversation and thinking about how Douglas County can more pointedly or refine its approach or its look at providing this kind of experience for the rest of us to learn from. And I really do appreciate the intent and understand the importance of it is. Our job is not to get all bogged down too much in this decision-making process and with process points. It's really the heart of the matter that we need to be concerned with. And for me today, that comes back to the budget, the staffing pictures, the curriculum, the planning, the future outlook, and goals and aspiration. The aspirational part of this for the community as well. So I will vote, and I thank you all very much. I thank all of you for your efforts in this. I think it's a good thing that Colorado is taking part in these kind of conversations. It's good stuff.
Thank you. I'm not sure that I agree entirely with Mr. Durham's approach to this, that this could save taxpayers money. That's not my goal. If we can provide an opportunity for these students to be educated, supported, prepared for a future life, I am all in. And yes, it's going to cost more. But right now the funding doesn't appear to be available to you. I think more work needs to be done to figure out what is the program. Based on your 188, I calculate that you've got approximately 31 kids per grade. There's nothing broken out to how you're going to manage that kind of a spread of students with a spread of needs, etc. It's just, you've been courageous, I think, to pick and to choose a really high need and start the process of looking at how do we do this? How do we help these kids in the most effective way? And for that, I think you should be really proud of yourself. Unfortunately, there's not enough there. Were we to approve this, and for the district to approve this, without being able to have the resources, the facilities, the people that are needed would be to definitely underserve a population that we worry about an awful lot and that deserves a whole lot of our help. I feel real strongly about that. I hope we can figure this out. It's a really difficult puzzle. Dyslexia, I don't want to say it was easier, but actually it is easier. The variations are not as great. The strategies actually apply to non-dyslexic, the teaching strategy to non-dyslexic. It's a different piece. So I want to thank you for bringing it forward. I can't support it right now because I don't think it's ready for prime time. And were we to approve it, I truly believe we may actually be harming kids, which is the last thing I want to see. And I'm sure it's the last thing you want to see as well. So I'll entertain a motion.
I move to deny the appeal on the basis that John Dewey Institute has not demonstrated that the denial was contrary to the best interest of the pupils, school district, or community.
It's a proper motion. Do I have a second?
Madam
Ms.
Chair,
Maramba, wherever you are. Oh,
I have a substitute motion. I move we approve or uphold the appeal against the district for the sole purpose of having the district correct the procedural problems of not having a proper resolution stated for the denial. And if I may speak to that motion,
you want to get your second first?
yes, thank you. Thank you, Madam Chair. Speak to the motion, a couple of points. There was a time when, not following proper procedure was accepted in a lot of areas of American jurisprudence, be it Miranda or be it having probable cause for a search warrant. I think the public is better served by and it is in the best interests of the school district and everyone else involved to have procedure properly followed, which in this case I do not believe it was. So, on the merits, I might choose to agree that the application needs some work, but without having the ability to properly respond to the issues, I think does a disservice to everyone, including this board. So I'll make that motion.
Could you repeat the motion?
That we uphold the appeal and remand to the district for consideration and solely on the procedural merits that they need to remedy before we come back with a final decision.
The reality is that that's not one of the reasons that we can use. It needs to be about the best interest.
As I stated, it isn't always in the best interest of the citizens for proper procedure to be followed.
Board Member Flores.
But the question is, if I may, ask our attorneys here, that is it in the Constitution that it must be written?
Statutes.
The answer is no, I can tell you it's
Is it in the
not.
statute that it has to be written? And that's what you're alluding to, Mr. Durham.
The statute does not specify that it needs to be written. It does specify that it needs to be a resolution, which can be read differently from just a vote and read to require more information.
And may I ask you another question? Did they provide a resolution to your?
I would say that legally, I think that is a close call. I think it would be reasonable to find that the vote they took was more than a resolution.
Board Member Tolson. I mean, I do this to you all the time. Counselor Tolson. Yep.
The statute speaks to how the local board would accomplish its decision in a couple of different places. One is the requirement that it rule by resolution on the application. I mean, as a practical matter, we should acknowledge the reality that those typically are written documents that include an enumeration of reasons, because the reasons are then agreed upon as the reasons of the majority voting.
But does it say written?
No, it doesn't. It says exactly what I just said. It says, shall rule by resolution on the application. The place that there's a written notice requirement is in the notification they send to the Schools of Choice office here at the department, where it says that they send notice to the department and in that notice state the reasons for the denial. And that letter here contained a hyperlink back to their board meeting. So,
Which did not meet the position of the statute. And if I may just opine, I have voted in my career on hundreds of resolutions, and this is not a resolution. I don't care how you cut it. Period. They did not provide a resolution.
Any other comments? Board Member Schaffel?
I just think that made it difficult for the charter applicants to respond. So I think that having a succinct resolution as opposed to each board member talking about why they voted, how they voted, is very different.
So what's the effect of this, guys?
May I?
No, let me
Okay.
ask a question and then it's your turn again. What's the effect of this?
This motion.
Yes.
Well, I think the practical effect, I mean, as you know, you appoint somebody to write a remand. So the motion I made contemplates that that would contain that they remedy the procedural errors. Now, that starts the process over, and probably doesn't lead to much of additional result or a different result, but it does at least send a strong message to school boards in the future that think they can short circuit the process, that they ought not to be doing that. And I am very much in favor of sending that message.
Yes.
Thank you. But aside from there not being really a case to say that they didn't, because I read over and over again, in fact, several documents where they are told that they didn't meet this, they didn't meet this, and this, and this. I don't know how many times I read it and how many documents. And so they got the message, but ultimately, the budget was not correct. They did not identify how they would really teach different cohorts of individuals with autism, without autism, in the document. They did not have, after 3 budgets, they did not have budgeting that would suffice. And it goes on and on. I don't know, but it was a very large document, and then all the additional material. You're right, it was just a lot of material to read. But in it, over and over and over, I think that Douglas County did make a very strong effort to let the John Dewey Institute know that this did not suffice, and it would not be good for kids in the district. So it is, the idea, I agree with board member Joyce Rankin. I think that she was on the dot as saying that, you know, this is innovative, it's great, and somebody has to do it. And I'm glad that you guys put the effort in trying to do this. But at the time, I don't think we can make a judgment to say that you should go forward with it. I think it needs much work. And that's encouragement. I'm encouraging you to work on it and to come back at another time to Douglas County or maybe another district to have such a school, because idealistically, I think people would really want to have your school, but
So
not
we
at
have
this time.
I have a substitute, we have a substitute motion, which is to remand this back to the district. Ms. Miranda, I'm really frustrated with not being able to see you also. You don't look that good as just plain old wall. Can we get you to sneak out for those of us who are blocked? Can you guys see her?
I can't.
I can't.
So we're voting on to remand it?
No, she's already sent her vote. We're okay.
Board Member Durham,
Yes.
Board Member Flores,
And it's to remand?
Yes.
No.
Board Member Goff,
No.
Board Member McClellan,
No.
Board Member Rankin is
It's
a yes. Board Member Shuffle,
Yes.
Board Member Schroeder,
No.
so that fails on a 4-3 vote.
Can we go back to the original motion made by Board Member Flores, seconded by Board Member McClellan? Thank you.
Yep.
You can call the vote?
Board Member Durham,
Yes.
Board Member Flores,
Yes?
I'm sorry, could you read the
Move to
motion?
Yes, deny.
Please read the motion.
Okay, I'll read it again. I move to deny the appeal on the basis that John Dewey Institute has not demonstrated that the denial was contrary to the best interests of the pupils, school district, or community.
Board
So-
Member Goff?
Board Member Goff,
Yes.
Board Member McClellan,
Yes.
Board Member Rankin. I don't have that vote, sorry. Board Member Shuffle,
No.
Board Member Schroeder,
Yes.
so that passes 6-1. I'm sorry, 5-1.
5-1.
5
Thank
to
you.
1.
I want to be really clear that everyone heard that substitute motion, despite the fact that it did not pass. I think there's a wish on all our part that you do these things the right way. I don't want to harm kids or take extra time, because that's really all. I appreciate that you did that, Mr. Durham, but all it does is add extra time to the whole process. And that's really not helpful for anybody. Thank you very much for coming. I appreciate it. Best wishes. Do not want to discourage you, but this is really hard.
I think, Madam Chair, I hope everybody heard it, because I hope we get any more of this kind of flailed procedure.
You might convince us.
There'll be a lot more than 4 votes to put a stop to this kind of goings-on.
Thank you. Take a 10-minute break, please. Is it noon?
Lunch?
Is it noon or 11?
No, it's noon.
It's noon.
Okay.
Welcome to the meeting.
Yes, thank you. We have Joyce Zerkowski here with us and Marie Hutchton with us today. Just want to give shout out to them. Their teams, both of them and their teams have been working very, very hard to get this out and get this released by today. And so with that, I believe I'm turning it over to Ms. Zerkowski.
Thank you. Madam Chair, I heard and took as a hint that you were a little bit behind schedule. So I'm going to go a little bit faster through some pieces that I think the board as a whole is very familiar with. Obviously, if I go too quickly, pull me back.
Remember, we're not the only ones here.
Yes, yes, absolutely. Perfect. All right, so what we're going to talk about is just a little bit of background information. Again, these pieces you may all be familiar with. I'll run through the results which have been released as of noon. We'll talk a little bit about participation and then the CMAS achievement results, PSAT, SAT achievement results, and then I'll be passing off to Marie.
And Ms. Zerkowski, our little mics got to get real close. Sorry.
I don't know how comfortable I am with this. All right. So when we look at the purposes of the state assessments, students and parents utilize these assessments, educators utilize the assessments, and yes, we know that they are utilized by stakeholders, policymakers, and the community. For students and parents, it really does serve as one indicator of the student mastery of the grade level standards by the end of the year. That is the question that it answers. At the end of the year, has your son or daughter reached, mastered those grade level standards? Also with SAT, obviously that provides a nationally recognized indicator of academic college readiness. From an educator point of view, teachers are able to see and compare how their students are performing to their school, to their district, and to their state peers. And that is one of the pieces that the state assessment can satisfy that the local assessments can't necessarily, right? It gives you a perspective across the state. It also provides teachers an opportunity to see how their students are performing against the standards. And then for stakeholders, policymakers, and the community, it allows for those comparisons. It allows for accountability, calculations, and provides a source of information as parents are making decisions regarding their sons or daughters' education. For our state assessments, we'll be talking about CMAS today and PSAT, SAT. Remember, for CMAS, we have math, ELA, and science. Math and ELA are given in grades 3 through 8, science 5, 8, and 11. And then we did administer social studies on a sampling basis to grades 4 and 7. We won't be spending a lot of time on social studies, again, given that not all schools and districts actually participate in that every year. And then I did want to note that for the PSAT, just the SAT, there is an optional essay that students can take. That is by student choice. That is not school choice. That is not district choice. That is by student choice. So when we look at what has happened since last year, we were very excited. I think the field was very excited that the assessments given at each grade remained the same. That is a first in about 10 years where everything remained the same. Yes. Again, the field has worked extremely hard through all these transitions, so have to give them kudos. This is the first year where we utilized solely Colorado-developed items. They were included as part of our operational items for our CMAS, ELA, and math. The other change relates to SAT, and the College Board has revised their administration requirements, and they are now allowing accommodations, actually accessibility features, for English learners. They are allowing glossaries, translated directions, and extended time. Utilizing those, students will get college reportable scores, and that is a first. Historically, if our English learners used any of that, they did not get college reportable scores. So, good news for them. Every time we have a chance, we like to point out that because Colorado is developing their own assessments in grades 3 through 8, and for science, we do utilize Colorado educators for our item writing, for our passage review, for our item reviews, for range finding data review, a lot of different pieces in the development process. In order to do that, we have to have educators. The website here is where educators can go and indicate their willingness to participate in that process. For the spring 2019 results, student level results, right, student level, were available as of June 18th for all of CMAS. Other confidential files and reports containing personally identifiable information were made available throughout June and July. For PSAT and SAT, those individual student level results were directly available to students starting in late May and going into June. And then educators had access to results through that College Board portal as of late June. Remember, with PSAT, SAT, that is the only assessment we give where students actually get their results before the schools and districts do.
With the CMAS, it's the district that sends out the result to the parents?
Correct.
Do we confirm that they have been sent, or do we have a deadline that we ask districts?
So we actually have different options for districts to follow. So we do have the individual student level results that are available in file format early in June. We also have what we refer to as on-demand reports. On those reports, you can see the students' performance on the test, so a scale score as well as the performance level. There isn't any comparison information. For schools and districts that are running really late into the year, they may share that. In terms of the full individual student level reports, schools and districts get those electronically first, and then they get hard copy. The electronic version comes in July. The hard copy comes in August per district request. That is when we send those. Some schools and districts hold on to those reports until they may have beginning of the year conferences. Others will be sending those electronic reports, well, as of half an hour ago. They wait for that embargo to end, and they literally, through their electronic system, hit send. We do not verify when every school and district is sending out their reports. We do provide them with guidance in terms of as soon as possible, which is also required by federal law. One of the reasons why some schools and districts hold off until those conferences is because in Colorado we have additional law that says teachers, educators must sit down and explain results to parents in an understandable format. So that's why sometimes they hold on until conferences.
Right, and some of us hear about it.
And some of you hear about it.
About the fact that they don't have the information as yet. So
And
the
we-
answer that we would give would be that when you have a conference in, September, with your child's teacher, at that time, you're looking for the report.
Yeah. And we
Okay,
have
thank you.
heard that there are some districts who hold on to those reports much longer than that. If we hear about that, we will reach out and suggest that maybe that was not as soon as possible. But there is some flexibility there. Communicating that at this point, all schools and districts have all of their assessment results is really important. So
Well, let
all
us know
schools and
if we
districts
need
have
to-
their
if we need
reports.
to help set a deadline. I've had more than one highly frustrated parent say to me, so-and-so has their data, why don't I?
More than willing with board direction
Okay, let's
to
see if-
put
let's see-
out that
Let's listen
we
and
will
see if it's
have.
a big problem or not this year. Okay, thank you.
Absolutely. So in terms of the CMAS and PSAT, SAT, and then our alternate assessments results, we did put out the overall results by grade level. We have also put out subgroup results at the state level for gender, race, ethnicity, economic status, English learner status, IEP status. For this year, second year in a row, we also put out the district and school level results at the same time. That's why some of my folks are very tired. CMAS and PSAT, SAT participation. When we look at grades 3, 4, and 5, you may recall that participation never fell to the level that we saw in high school. At this point in time, grades 3, 4, and 5 are all above 95% participation. When we look at 6, 7, and 8, that is where we have seen some increases. So in grade 6, back in 2015, we had about 92.5% of our students participating. That's now up to 94.7%, really getting close to that 95%. 8th grade, which has the lowest participation rate in terms of our 3 through 8 system, in 2015, they were at 85%, and now they're close to 89%. For grade 9, and 10 and 11, that is where we had seen the significant drop in participation. We have seen participation significantly increase since 2015. We believe that a lot of that is reflective of the fact that we are now utilizing the SAT suite, and parents and students are finding those assessments more useful, so they have re-engaged with the system. As an example, when we look at grade 9, in 2015, we had about 70% of our students participating, and now that's over 93%. When we look at participation rate by subgroup, when we look at grades 3 through 5, all of our subgroups are above that 95%, except for our IUP subgroup and our non-English proficient subgroup. When we look at 6 through 8, now our subgroup performance, most of those have dropped below 95%, but they're still above 90%. The only subgroups that are below that 90% are the IEP subgroup and the non-English proficient subgroup. When we look at high school science, everybody is below 95. Everybody is below 90. Everybody is below 80% participation, and at that point we have significant impact in terms of the distribution of our students. So in some cases in our grades we have a very similar percent of our students participating by subgroups, so our females are close to, at our younger grades, 95%, as are our males. As we look at our higher grades, as an example with race and ethnicity, we would expect to have about 55% of our students be part of our group, and instead we're down to about 49%. For our Hispanic, we would expect them to compose about 33% of our tested students. Instead, they are composing about 38% of our students. Because of these differences, it is very difficult to interpret our results for science, high school level. When we look at grade 9, 10, and 11, participation starts to increase. So now we see, in most cases, participation over 90%. The exception is our IEP and non-English proficient subgroups, but every other subgroup has gone up above that 90%, with the exception of, I believe, free and reduced lunch at 10th grade. So in general, we are seeing some incremental increases in ELA participation and math. They follow a very similar pattern. Grades 3 through 5, over 95. The only grade falling below 90% in our CMAS 3 through 8 was again grade 8 at 88.7%. Subgroups, students with disabilities and our non-English proficient, subgroups are participating at a lower level than the rest of our subgroups. For grades 6 through 8 in ELA at the state level, again, with the exception of students with disabilities and non-English proficient, all of our subgroups had participation rates above 90%. Our non-participants continue to be disproportionately white, economically better off, Native English speakers, and students with disabilities. While our Black and Hispanic subgroups participated at a lower rate for CMAS EL grades 6 to 8, let me try that again. I knew that sentence wasn't making sense to me. So for our Black and Hispanic subgroups, their participation dropped between grade 6 to 8 to grade 9, while our participation for our Asian, white, and 2 or more race subgroups actually increased. So we see those groups diverging. For our white subgroup, when we look at grade 8 and then compare to grade 9, they actually increased their participation by 7 percentage points. When we look at grades 3 through 8, our students who are eligible for free and reduced lunch are participating at a higher rate. When we get to PSAT and SAT, that reverses, and they're participating at a lower rate. Really meaning that those students who are not participating are participating at a higher rate as well. And our students with disabilities, their participation rate is still at about 90%. I have a lot of information about what achievement looks like for these assessments. I'm going to run through relatively quickly. There's a lot of them, more than willing to talk about them at another time. This is a bar graph of our ELA, again, grades 3 through 8. Achievement, we are in our 5th year of administration of ELA and math. So we can look across 5 years. As you look across for each grade, there is a trend of improving. The amount of that trend, the strength of that trend does vary by grade level. Our grade 3 students have had the lowest level of increase in the percent of their students who are meeting and exceeding standards. They've moved from 38 to 41, 3.1% increase, percentage point increase. Our highest was actually at grade 5 with almost an 8 percentage point increase. And you can see the rest of those. I did want to talk briefly about how our ELA assessments are comparing to NAEP. And we have included NAEP scores from 2015. For grade 4, it is that first bar, that's aqua. And then we also included it in grade 8. Again, it's that first bar, that's aqua. It does appear that the NAEP expectations are actually slightly higher than what Colorado's expectations are. We have fewer percentage of our students meeting the NAEP expectations than meeting the Colorado expectations. And you can see that it's about by 10 percentage points.
May I ask you a question?
Sure.
Is it criterion? No, sorry. Is it criterion?
Reference, is there a difference in ours in comparison to NAEP?
It is definitely criterion referenced. So NAEP does have what I'll refer to as their standards. They do have content descriptors for each one of their levels. And so it follows a very similar process to ours. There are differences, some differences in terms of what those standards are requiring at each of those levels. One of the most significant differences between Colorado and NAEP is that we include writing within our ELA assessment, and NAEP does not. I'm going to jump to math for a second, not just for a second. Yes?
Go back and run
Yep.
by that again. So the NAEP for 4th grade is 39?
So NAEP for 4th grade, 39% of the Colorado students are meeting their benchmark.
Got it. Misread it. Thank you very much.
Sure. In your packet, you are going to see a number of these horizontal bar graphs. What we have done is we have lined up that bar that indicates the student has met the expectations evenly across the grades and across the years. What we would hope to see is across time, we would have the green and, again, aqua bar become larger and larger, while the orange, blue, and yellow reduce. It's important to note it is still important to note that when we're looking at our students who are not above the bar, there are 3 different divisions of those students. And when we look at the yellow bar that indicates the percent of our students who are at approached, those students are nearing mastery of the Colorado academic standards. They're close. They're not quite there yet, but they are close. So with some additional instruction and focus, we expect that they should cross over into the green area. With that said, of course, we want all students to receive a high quality education, and all should get attention. So when we look at the key facts regarding ELA achievement, the percentage of students meeting or exceeding expectations has improved in all grade levels from 2018, with the exception of grade 7 that actually decreased by 0.1 percentage point. The range of improvement is 0.8 for grade 6 up to 3.1 for grade 8. And I'm going backwards just for a second. When you look at this
Welcome to CenturyLink
bar
conferencing.
graph,
Please enter your
you do
passcode
see
followed
that
by the
for
pounder
grade
hash
8,
key.
that is where we
And
see the most significant increase. We will be looking to see what
Please
happens
hold while I
next year
confirm
in
your
terms of,
passcode.
is that a trend? Is that going to
Thank
be
you.
maintained?
Your passcode
Or
is
is that a
confirmed.
single year
When you
kind
hear
of
the
a
tone,
blip?
you will be the first
They were
person to
obviously
join the
already
meeting. The line
on
will
the
be
incline
silent until another
consistently, but
person
that
joins.
is a pretty significant increase. When we look at math, math is not as consistent as what we see with English language arts. You'll notice that we have shaded out math grade 7 and 8 for prior years. The reason for that is we have a different group of students who are participating in those assessments this year than we have in the past. This is the first year where our high school end of year assessments were not part of our system. So now all students are taking 7th and 8th grade math. So our advanced math students who perhaps 3 years ago would have been taking algebra or geometry are now taking that 8th grade math assessment. And so it's not really appropriate to compare performance in 2019 to prior years. If you look really carefully below the shading, you can see how big of a jump it is, but we don't want people to misinterpret what that is. When we look at the changes from 2015 to 2019, for grades 3 through 5, there's a range of about 3.4 to 5.6. Then we have grade 6. And that has been a relatively stable population in terms of who is taking the assessment. But in grade 6, we did see a decline in terms of the percent of students who met or exceeded standards. And that
Every
does appear to be a trend. You almost let me get by this slide. We also have on this slide NAEP performance for grades 4 and for grade 8. And again, those would be the aqua bars. I'm going to start with grade 8 first because that's an easier one for us to have a short conversation about. On NAEP, we have approximately 37% of the Colorado students meeting expectations, and on our state assessment, we have approximately 37% of our students meeting expectations. So very similar in terms of that grade 8. Then we go and look at grade 4. And at grade 4 on NAEP, we have approximately 42% of our students who are meeting the NAEP expectations, while 34% of our students are meeting expectations on grade 4.
Is that because of writing?
So this is math.
This is math.
Oh, math, forgive me.
But happy to talk a bit about what are some of those differences. When we look at the NAEP assessments, about a third of that assessment actually is assessing K through 3 skills instead of grade 4 skills. In addition, when we look at one of our key standard areas, NAEP does not address that as consistently, as much as the Colorado assessment does. The Colorado assessment, keep in mind, really does follow the Colorado academic standards in terms of what it is that we're assessing. That area is actually operations and algebraic thinking. What is covered in that standard area is problem solving related to word problems, the using for operations, generating patterns based on a rule, finding factors and multiples of whole numbers. Again, not again, but really the basis of what allows students to then learn more math in future years. When we look at what's happening at grade 4, where it appears that we are performing at a higher level on NAEP, we need to keep in mind a third of that test is based on K through 3 standards. That test is not focusing as much on the operations and algebraic thinking. By the time we get to 8th grade, we are leveling off with NAEP. So when we're looking at that grade 4, I would suggest they are measuring some different aspects of mathematics.
May I ask a question? Word problems.
Mm-hmm.
So we have a lot of word problems on
Mhm.
our test.
Yes.
Does NAEP have as many word problems as we do on our test?
NAEP does not have as many word problems on their assessment as we do on our test, which also absolutely comes into play whether or not you can be presented with a situation and actually apply the math. So yes, that is another one of the areas of difference.
And would you say that that would be the reason or a big reason? Did you kind of come to what percentage that might be the cause of
I would say that
difference?
I would say that it is definitely a contributing factor in terms of what we're expecting our students to be able to do and to demonstrate.
Yeah, because
With some of those, when we're looking at those constructed response kinds of problems that you mentioned, you can't guess at those answers, right? Whereas with multiple choice, there's some guessing opportunity, and typically, even at the low level, it's about 1 in 4, right? If you have
Well,
4 answer choices.
I would attribute it to
is-
reading rather than guessing.
So you also have with both assessments, I would suggest there is a reading component. Keep in mind that for CMAS, we do have for mathematics a Spanish transadaptation of the assessment that is available. That is both in writing and also orally. We also do have for even our native English speakers who may struggle with reading presentation orally. So we do try to minimize the impact of that reading skill on a student's ability to demonstrate their math skill. They still have to be able to process situations that require mathematics application.
But I just wonder if they know that they can choose the other, and it's all online, and also, whether they can use a computer well. I'm sure that that is probably a contributing factor. Is NAEP done on a computer as well?
NAEP is transitioning to what they call digitally based
But
assessments.
right now,
but yes.
it is on paper.
They
So that
they have
could
been
be-
transitioning over the course of the last few
Right,
years,
but
and it depends
most-
on which assessment you're talking about. And to be honest with you, I'd have to check to see where they are in terms of the math.
I think it is paper and not on a computer. So I think that would be another contributing factor, especially given that many of our rural students do not have that you know, is the lines and the technology and such, so that could be a suffering, you know, that, so there's multiple variables that I think we can say why they are not, if we are making a comparison between NAEP and our exam. One reason why I think that if the feds would want it to do this, I mean, if wanted to do it right, I really feel that they should pay for it. Let me finish, please. So I think if they want the test, they should have the test, and there's NAEP. The comparisons are close. So why burden the states with not only the expense, which they want, they should pay for it. And we shouldn't have to pay for it. They want, and I think ultimately this group at the very beginning when we were discussing it, we did think, the large number of us thought that, that, you know, they wanted a test, they should have the test, that they should pay for it. And we should really be on with our mandate of educating our kids and not really take so much time with standardized assessment.
Thank you, Board
which we
Member.
do. Thank you.
Please proceed. Joyce.
So again, in your packet, you will see these horizontal graphs. I'm not going to walk through them. The right-hand side is what you basically saw on the prior graph, except it's been tilted on its side. But we do have here the other three performance levels referenced, so that you can view those students who are approaching, crossing that line for meeting expectations, and then students who are not as close. For CMAS 7 and 8, I already talked about this in terms of you can't really compare grades 7 and 8 to prior years because of the change in performance at the state level. Not change in performance, but change in administration at the state level. When folks are trying to compare districts to schools, they also need to be aware of that grade 7 and 8 and how that comes into play. We have had some schools and districts who have always been administering the grade 8 assessment. We have other schools who were administering algebra, geometry, etc. So making those comparisons really, really difficult. So caution. This slide basically goes through what we've already talked about. When we look at the range in terms of the percent of students who are meeting and exceeding expectations, at the low end, we do have grade 6 at 29.5%, all the way up to 41% for our grade 3. There were increases since 2015 that ranged from 3.4 to 5.6. Again, we did look at grade 6 and we know that that actually had a decline. Science and social studies, remember we give science in grades 5, 8, and 11, social studies sampling basis in grades 4 and 7. Performance here, a little less consistent when we look at grade 5, although there is a slight increase from 2015 of 1.1 percentage points. Grade 8 has been a little bit more steady in terms of the percent of students who are meeting and exceeding standards, 2.5 percentage points since 2015. High school science, because of participation issues, you can draw whatever conclusions it is that you want to draw. Actually, I would say be very hesitant about drawing any conclusions based on the participation issues, but there's the data. Grades 4 and 7, again, done on a sampling basis. 2019, slightly higher than 2015 for 4th grade, relatively consistent for grade 7. Again, similar graphs. Notice we did shade out grade 8 because we are discouraging overutilizing the results from that assessment. Science, again, this is basically bullet points of what we have already gone through, so I'm going to move ahead. we have a number of slides that actually deal with differences in performance based on subgroup. Some of these slides, you may be able to guess what it is that we're going to see. For ELA, females continue to outperform males. That has been consistent throughout CMAS, throughout a lot of the different assessments, historical assessments and other current assessments. Grades 6 through 8, again, we see a continuation of females outperforming our males. When we look at math, I want to focus in on grade 3 at first. Notice that back in 2015, males and females were very close in terms of their performance. That performance has spread across time, although we've seen increases for both of those genders. Grade 4, again, we see a bigger spread. There have been increases for both. Interesting, it's not interesting. But I will point out that for our females, they had actually been increasing, and then they have now, they're showing a trend of having fewer students meet and exceed. Still higher than when we started in 2015, but something that we should continue to watch. In grade 6 math, that is where we have the smallest gap between our males and our females. And you'll notice that there was actually a flip in terms of who had a higher percentage of students. In 2015, it was actually our females who were meeting and exceeding at a higher rate. At this point, it is our males. And again, 7 and 8, we've blocked out. For grade 7, looking just within this year, don't look historically, but looking just within this year, males and females are within about 0.2 percentage points, so very, very close to one another. Our males and females just within 2019, not looking historically. Our males are meeting and exceeding at about 3.4 percentage points compared to our females. Science, kind of a mixed set of results. For grade 5, initially there was a little bit of a spread between our males and our females. That gap really has closed across time for grade 5. For grade 8, we've actually seen an increase in terms of that spread. And for high school science, again, I won't comment a lot on that. In the next slide, we have results based on race and ethnicity. We continue to see in 2019 a similar kind of gap that we saw in 2015. Our white, Asian, and 2 or more race subgroups are outperforming our Black and Hispanic subgroup. It is important to note that all of our subgroups are performing at a higher rate in terms of met and exceeded. It's just not enough to adequately close the gap. Very similar pattern with grades 6 through 8. Math, again, you're going to see very, very similar patterns across most of these graphs. Science as well, in terms of how those are kind of breaking apart. Then you will see for grades 3 through 5 ELA, looking at students who are eligible for free and reduced lunch versus those who are not eligible. Our students who are not eligible are meeting and exceeding at a higher rate than our students who are not eligible. Again, when we look across time, our students who are eligible are improving, but not at a rate that allows them to catch up to those students who are not eligible. Again, you're going to see very similar patterns as we look at ELA grades 6 through 8, as we look at math, as we look at science. You'll then see ELA grades 3 through 5, looking at students who do have a disability versus students who do not have a disability. Again, what you see is that students with disabilities are performing better in 2019 than 2015, but not at a rate that will allow them to actually catch up adequately. And you will see a similar pattern as you go across the years, and in some cases, that gap is actually increasing. Math 3 through 5, again, similar pattern. Grade 6, with grade 6, we actually, again, have seen that decline in performance for both subgroups. Our students who are not in an IEP actually show a bigger decrease in terms of percent who are meeting and exceeding than our students who do have an IEP. Do have to acknowledge that the percent of our students who have an IEP has always been very low, so they started at about 5%. Science for grades 5 and for grade 8, again, similar pattern. English learner status for grade 3, when we're looking at our former English learners, these are going to be our students who are designated as FEP or as FEL. They are not our students who are designated as non-English proficient or limited English proficient. Those we refer to as English learners. So our English learners are our subgroup that is lowest performing. Grade 5, that is where we see the most significant increase in terms of how that group is performing, but again, they are not performing or increasing fast enough or by enough to actually catch up to what the other groups are doing. When we look at grade 5 ELA, we do look at our former English learners who were performing at a lower rate in terms of percent of students meeting and exceeding in 2015, and now in 2019, they are exceeding our students who have never been English learners. Grade 6 and 8, you do see in grade 7 where those subgroups in terms of never English learners and our former English learners have been very, very close to one another. We did see this year a separation. We will look next year to see if we really do have a start of a trend or if this year was just an aberrant year. Math, in grade 3, our former English learners are outperforming our students who are never English learners. Keep in mind that is a very small number of students who are identified as that at the 3rd grade level. In grade 4, we actually see the gap between those former English learners and our students who are native English speakers actually increasing across time. In grade 5, that has decreased to being almost identical. We do have in grade 5 for our students who are English learners an increase of about 3.5. Again, not fast enough to meaningfully be closing that gap. Grade 6, then we have grade 7. It is our students who have been native English speakers who are showing the most significant increase when we look at grade 5. That's your middle set of numbers. Not much to comment on. Key information, females outperformed our males in English language arts. with a 7.1 percentage point difference in third grade and a 19.2 percentage gap in eighth grade. So we see that increasing across time. Males outperform the females in grades 3 through 7 for math, and in grade 8, females outperform males. There is information about the Black and Hispanic subgroups in relationship to our white subgroup. Those gaps range from about 24 percentage points up to about 29 percentage points. Those gaps, again, have remained relatively unchanged. For students who are eligible for free and reduced lunch, again, we have these gaps that are two-digit gaps ranging from about 19 percentage points to more than 30 percentage points. Those, again, have been persistent. We see the most significant difference in sixth grade math. And then for our students with disabilities, the gap ranges from 28 to 44 percentage points, with the highest being at grade 8 ELA. PSAT, SAT. I wasn't moving my slides along the way in front of me. Wanted to provide a reminder that when we're looking at PSAT and SAT, most of us are familiar with the SAT scale that goes from 200 to 800, right? We have some familiarity with that. PSAT 10 is slightly lower. It goes from 160 to 760, and then PSAT 8-9 goes from 120 to 720. So it is on a vertical scale. A student who is taking PSAT 10 cannot score an 800. It's impossible. It stops at 760. Important to keep in mind. When we are looking at mean scale scores, with PSAT 9, this is only our second year of administration, so it's hard to talk about trend, but the mean scale score for total score, right, so this is that 400 to 1600 score, is up by 4 scale score points. When we look at PSAT 10 and SAT, we do see a decline. For PSAT, that decline is 5 scale score points. For SAT, the difference is 13 scale score points. Now again, important to keep in mind that for this scale now, we're talking about a range of 400 to 1600, right? So it's a relatively large range, so put that 13 kind of in perspective with that. However, we did see that change, and that was an unexpected change from our end. And whenever we do see an unexpected change, we go back to the vendor and we work with the vendor to review all of their technical processes and procedures, and review what I'm going to call their logistical processes and procedures. So that includes looking back at equating, looking at the items themselves, looking at the scaling, also making sure that what gets entered into the system in terms of tables, like our raw score to scale score table, is the accurate table to put in there, making sure that the item stats actually are the right item stats to go in there. College Board has they have a rigorous process ordinarily. So they have a lot of those pieces that are independently validated all along their process. So they have 2 systems that are scoring, and then they cross-check those. When we went back to them, they introduced a 3rd system that was independent of the other 2, scored exactly the same way. There was no variance. They did review all of those equating, those hardcore technical procedures. We did ask 2 additional psychometricians who have a lot of credibility, a lot of experience, a lot of knowledge to also review those procedures. In the end, they followed the professional standards in terms of all of their technical pieces, and there were quality control pieces and a review of those quality control pieces in terms of the logistical steps that needed to be taken. College Board is standing behind these scores, saying that they are reliable and valid. The department has reviewed that entire process, and again, with external support in doing that. These scores, I would suggest, are reliable and valid. They can be used for their purposes. With that said, just like any system and definitely any assessment, there may be opportunity to increase that validity and reliability. We do the same thing with CMAS, and College Board has demonstrated a commitment to look through all of those processes and procedures and to do that alongside Colorado. So we will have some input into that, as well as bringing in those external experts to review to see if there are some things that can be done.
Were we different from other states?
So other state results are not put out yet.
Oh. What is the standard deviation with the PSAT? I mean, within the latest?
I can get that to you. It is relatively small, but I'll get that to you.
Not 50 like before.
I do not believe that it is 50.
Okay.
Keep in mind too that when we're looking at these changes, that for PSAT and for SAT, as you may recall when maybe some of you took the SAT, I don't know, but those scores are by tens, right? You can score 420, 430, 440. You cannot score a 435. So as we're looking at changes, and we're looking at this with PSAT 10, a drop of 5 points, that is within the options, right, that you have. If I'm at a 410, I may be able to get as high as a 415 if we would say that this was too low, but they weren't making it to 420. Basically what College Board does is they take their scores and they multiply them by 10. So there's always a 0 at the end. PSAT, what we looked at before was the total score, so it was what they refer to as the evidence-based reading and writing combined with the math. For PSAT 9, there was a slight increase. For PSAT 10, a 1-point increase over what we saw in the first year. And then for SAT, we saw an 8-point decrease. Keep in mind that we have different numbers of bars because we introduced each one of these assessments in a different year. So we started with PSAT 10, we moved to SAT, and then we went on to PSAT 9. PSAT 10 in this upcoming year will be administered for the 5th time. As an aside, every 5 years, we are required to go out for a competitive procurement for our high school assessments. Mean scale scores for math, PSAT 9, steady. I thought that was such a good slide in. No, in all seriousness, we have been talking about that. For those of you who were around when we did this last time, we recognize that perhaps some earlier, more intensive communication might have been beneficial. So we are, when we're going out, we are reminding people that this will be our 5th year under this contract, under this procurement. For 2021, that will be the first year under the contract that results from the next procurement. So
next year.
Next is so hard, you know, I mean, is next like 2020 or is it 2020? Anyway, so one more year. For math, PSAT 9 is constant. For PSAT 10, we see a 6-point drop. For SAT, there is a 5-point drop. Again, we will be looking to see whether or not that becomes a trend next year. I do have slides that go over all of the subgroups in terms of performance for PSAT 10 and SAT. I did not include PSAT 9 because we only have 2 years of data. So when we're looking at the PSAT 10, we do have the females with slightly higher scale score points than we have males. When we look at the SAT total score, some similarity, but I will admit I need to go back and look at that. We do also have the race and ethnicity information that you are welcome to look at. We're seeing a range of about 200 points from the lowest subgroup to the highest subgroup for PSAT 10, and we're seeing about a 200-point range for SAT on a scale that goes, okay. I'm getting head nods saying, we got it, keep going. Free and reduced lunch. We have very similar gaps on SAT as we do on PSAT 10. There are gaps, they are relatively consistent. Disability status, again, definitely there are gaps. They are relatively consistent between the two assessments. English learner status, again, we have gaps. They are relatively consistent between the two assessments. Notes from background. For gender, we do now have these broken out by the evidence-based reading and writing and math. You will see that there is a bigger spread between the evidence-based reading and writing, with females outperforming our males. The gap for math is smaller, but it is our males who are outperforming our females. If it's okay with you, I'm going to go through these next slides really quickly because I want to get to another set of slides. If you have questions later on, please feel free to ask. I don't think there's anything strikingly surprising.
Except when you have an acronym, would you please spell it out?
Yes.
Whatever that is.
Yes, and I believe we have it spelled out somewhere, but again, we will make sure that it's spelled out on every slide, because we do understand that these slides are used in isolation of one another. That evidence-based reading and writing is just so long.
Well, no, that's
But-
fine, but.
Oh, yes, we'll make sure. I appreciate the feedback, seriously. College Board also has, in addition to their scale scores, they have an established college readiness benchmark that is based on performance of students in their first year of college, so there is some evidence behind that. Students, when they receive their score reports, do receive information about whether or not they are meeting that college readiness benchmark. So they are familiar with it. They are watching for that. They know where that bar is. We will be coming to you as a board in the next 6 months probably with cut scores for Colorado. We do need to take the SAT and establish cut scores just like we have for CMAS in terms of different levels based on content, based on criteria. But I did want to note that College Board also has a single cut, and students and parents get information on that. You can look through the college readiness benchmarks. You will see similar differences in terms of what we saw with the scale scores or patterns. Looking at the key facts, I believe I addressed most of these. When we do look at that gap in terms of total score, I will point out that for Black and Hispanic students compared to our white students, that gap is 137 points to 161 points. Those are significant gaps, and they too have remained relatively unchanged, consistent with what we have been seeing with our CMAS assessments. For our students who are free and reduced lunch, again, we have gaps of 140 to 153, so they're slightly smaller in terms of their range than what we saw up above, but again, significant. And then for our students with and without disabilities, that gap ranges from 190 to 222. That is our largest gap in terms of our subgroups. Did want to mention two pieces. College Board does have waivers as part of their process. So for students who are eligible for free and reduced lunch, they have access to some additional benefits and opportunities. they can get additional free test registrations. So for students who took SAT as an example this spring, and they do happen to be eligible for free and reduced lunch, they can retake SAT next year at no cost to them. And we don't believe that that's something that a lot of people know, so I'm taking this opportunity to be sure that, well, to try to get that out. Also, they have access to unlimited score reporting, and there's no end date to that. So you may have a student who, as they're graduating, say, I'm not going to college, and 4 years down the line say, but now I want to go to college. Unlimited score reporting for free. And then College Board has established relationships with some colleges, and they're hoping to expand those relationships. But there are application fee waivers for our students who are free and reduced lunch. And for those of you who have high school students who might be engaging in this process, you know that some of those costs can get relatively hefty depending on how many schools your child wants to apply to. So again, this really, the hope is it will get rid of a barrier for our students who are eligible for free and reduced lunch. Another program that College Board has just started is their College Board Opportunity Scholarship Program. The goal from College Board's perspective is really to get students engaged in the process of applying to college, especially those students who may not have parents who are familiar with the process and frankly find it all relatively intimidating. So they are trying to encourage students to go through that process, starting off with build a college list that you might be interested in. And what they are going to do, kind of on a lottery, in a lottery kind of way, is they will award 600 $500 scholarships. This is nationwide, so we have perspective. Second step is engaging in some practice for the SAT, utilizing Khan. Those scholarships, there's 1,000 of them, and there's more, 1,500 of those scholarships. Going through all the way to well, actually I'm going to stop at number 5, which is completing the FAFSA. No, students do not provide the FAFSA to College Board. You actually get a little certificate at the end, or certification that says you've completed your FAFSA. That's what they provide. So they're not providing other types of personal information. There are 800 of those scholarships for $1,000 actually applying to colleges. There are 500 scholarships for $1,000 for students who complete all 6 of those processes. And again, this is nationwide. I need to give us perspective. They will have 25 scholarships for $40,000.
There's 6,000.
There's some. They are just trying to incentivize students who may be hesitant to engage if it's appropriate. I don't know the details, but there have been some Colorado students who have won some of the smaller scholarships at this point in time. There is a time frame in terms of when they are awarding these different scholarships. We have been asked if students have not already completed their college list. Well, can they still do it? Absolutely, they can still do it, but this is the timeline under which the scholarships will be awarded and what is recommended in terms of having students engage in that process between their junior and senior year. So again, I'm just taking that opportunity to share that, those opportunities. And with that, I'm passing off to Marie.
All right, so as long as no one has any questions, we'll get started on the growth results. Oh,
Go.
okay. Just like, don't wait, go.
I think that's what she said.
All right, so the presentation for growth is going to be considerably shorter and less detailed than the one we have for achievement, because Joyce has really gone into such depth and information provided to us around all the assessments. So growth is sort of this next step. So today's presentation, we're going to do a brief overview of sort of what is growth and why we're using it. And then we're going to be looking at summary level state information for the CMAS grades 4 through 8 growth and some notable trends. We are not planning on presenting anything about the PSAT and SAT grades 9 through 11 growth. As Joyce had said, they had done some additional validation procedures, and that sort of delayed the time that the Accountability Office received that data, so we were not ready to publish that at this time. So our intention is that we will be making that public to districts, we'll be making that available to districts August 21st and then publicly posted on August 26th, sort of in alignment with the performance framework data. And then finally, we'll sort of provide some information about where public reports are available and how to access those. So the first thing is sort of, the bigger question, what is student growth? So growth data shows how much progress individual students have made between the previous year and the current year as measured by our state assessments. And we only include English language arts and math because those are the ones that are given every single year. And then student growth percentiles are determined by how much students have progressed in comparison to their academic peers. So not demographic information, it's exclusively based upon your academic peer group, so your previous score peer group. And then finally, growth data can be summarized by specific groups of students, schools, and districts. And then the way sort of we do that and providing additional information is, for different perspectives, is that growth shows how well schools are doing in helping each student progress. So all students can show growth, including students who are high performing. And growth is also integral to the accountability determinations. At the elementary and middle school level, 60% of the plan type rating is based on growth, and at the high school, 40% of the plan type rating is based on growth. And then finally, growth data informs improvement planning within schools and districts. So districts really value the growth information that they get and what it's telling about the instructional efficacy of their schools and for planning purposes, how they can potentially improve those instructional programs. So then how do we look at student growth? So we start out at the student level. So students can have student growth percentiles that range from 1 to 99. Those can then be aggregated up using the median, which is sort of the middle score. And so for schools and districts, the range of median growth percentiles usually technically runs from 1 to 99, but generally tends to fall between 20 and 80. And then at the state level, because we have such a larger population and everything sort of clumps towards the mean, or the middle, the median growth percentile usually ranges between 40 and 60. And so then because growth does look at assessment scores over years, we do have sort of this graphic which shows the years of data that are included in the 2019 growth percentiles. And I do want to make a note that for CMAS grade 8 to PSAT grade 9, and then we are not going to be actually calculating growth back from the CMAS assessment onto the PSAT assessment. So we're sort of cutting off the growth scores for PSAT so that it only looks at the SAT sweeped results.
So what can we say about grade 8 to grade 9?
So in investigating the data in preparation for the 2019 growth calculations, we realized that there was a little bit of a difference in the assessment construct underlying CMAS versus PSAT, largely having to do with the constructed response items and the writing construct that we have on the CMAS assessment does not quite align with the PSAT evidence-based reading and writing construct that does not have those constructed response items where the students are actually required to, write out sort of productive answers instead of sort of just responding to the selected response items as the rest of the assessment.
Except when we did this, we assumed we could make that shift, right?
Yes.
We believed that we could go from 8th to 9th grade, which is a critical transition time for kids, and measure growth, and we can't.
So we are still able to go from grade 8 to grade 9 in math. We did examine those data very closely, and the math construct is very consistent between middle school and high school, but for the ELA and evidence-based reading and writing, it has not turned out as I think we had anticipated or hoped it would.
Confession.
Yep.
Well, it's
That's right.
And we.
That's where we have such a big drop off, really is.
And we did hear from our technical advisory panel about how important growth was and that they really wanted to try to preserve as much growth as we possibly could. And so that was, you know, the biggest reason for including math, even if it's causing a little bit of inconsistency in the data that we're reporting. But it's important to have that. And so then for some results from the CMAS growth for grades 4 through 8, so just looking at state level trends by different disaggregated groups. So you see here, you know, as happens with our normative system, the all students median growth percentile is 50. English learners is actually also right at 50, so we have seen that English learners make progress between years that is pretty impressive and on par, you know, with the majority population. We see that free reduced eligible students, their growth percentile is around 47. For female, it's around 53, male is 47. Gifted and talented is 58, IEP is 43, migrant 45, minority is 48. So for all of these student groups for English language arts, they generally do trend to be around 50 and sort of just minor deviations. And that is the advantage of growth, is that students from those demographic, historically underserved demographic groups are oftentimes able to show the progress that they have made over time and get credit for that. And then for mathematics, we do see very similar patterns. For, you know, the all students still at 50, English learners 50, free reduced lunch is 47, female is 51, male is 49. We continue to see those, you know, gifted and talented students considerably outperforming at 58. Students on IEPs are our lowest subgroup at 44. Migrant is at 46. Thank you. And then minority is 48.
So can we argue that we're doing a good job with gifted students? That they're not, because that they can continue to make significant growth?
I would say so.
I mean, is that an appropriate?
The GT population on the whole is making significantly above average growth, and that's even in comparison to their other academic peers with similar levels of performance.
And we would expect that?
I mean, I think that we would hope that that would be the case. And I do think that it probably shows that a lot of our GT programs, you know, or I should say that a lot of our GT students are getting a lot of the skills that the rest of the students are also being taught in the regular classroom, and really making substantial progress over time. I'm probably not the best expert on that one, as I'm like flubbing that up a little bit. I'm like, I don't know actually a lot about GT instruction, sorry. I'll just stop now. We should get an expert in if we want to talk about that more.
You winged it that well.
Yeah, thank you. And then the next part of the presentation is sort of talking about trends over time. And so we're going to be, you know, pointing out a couple of the disaggregated group trends that we've seen across years. So the first one is that we do continue to see sort of the historical gaps for the racial ethnic groups and students who qualify for free reduced price lunch programs that we see in achievement. And so, you know, the slides that we're showing now show us the 2016 through 2019 growth results. And you can see while there has been, you know, some fluctuation over time based upon the different race or ethnicity group, in general, we do still see that Asian and white students are outperforming sort of our Native American, Black and Hispanic students, as well as the Hawaiian Pacific Islander is a little inconsistent, and it's also a very small subgroup, so it's hard to really make any significant claims around that. And then for mathematics, we again, you know, have seen some variability over time, but in general, we do still continue to see gaps for our minority subgroups. And then for free reduced lunch, when you look at the population overall over time, we've seen very consistent for non-FRL students. They've maintained around a median growth percentile of 52 in ELA. For the students who are eligible for free reduced price lunch, we've seen a little bit of variability over time, but it's stayed pretty consistent around 47. And we see almost exactly the same sort of gap for mathematics. 52 to 47, although that has shifted a little bit this past year. And then we also look at English learners, and one of the bright spots is always that English learners really do show significant growth that is usually sort of on par with non-English learners in both English language arts and math. And so you can see, again, this year has been fairly consistent, particularly in English language arts. And so, you know, the non-ELs are at 50 and the English learners are also at 50. For mathematics, this is the first year that ELs have been on par with their non-English learner peers in mathematics and getting a MGP of 50. So that's something. And then we also, you know, have continued to see that female students show higher growth than male students in both English language arts, and then math is a little bit different for this year. So for ELA, we have seen a little bit of a decline in the female median growth percentile. So right now we're at 53, and then male had a little bit of a bump up to 47. For math, we kind of get the opposite, where we've seen a little bit of bump up for females, which is now at 51, and then male has bumped down to 49. But those are still pretty close, and I anticipate that, you know, in future years we'll probably see them continuing to fluctuate just around 50. And then finally, students with IEPs, they continue to show the lowest growth, as I said before, of any group. But we have seen increases over time in both English language arts and math, which is kind of a positive sign. So the non-IEP students continue to have a median growth percentile of 51. We have seen, as shown by this graph, that the students with an IEP have improved their median growth percentile every year. And so this year we're at the highest that they have been, which is a 43 for ELA, and then a 44 for math. So that is a positive sign that it seems like we are doing something to improve the instruction for our students with IEPs. It's still not necessarily on par with our, you know, non-IEP students, but it is making really great progress. And then some information about the growth data release that we want to put out there. So all the schools with and districts and state summary information are now available, as Joyce has said, as of noon. That got posted. And so this includes overall performance and then performance by level, and includes the disaggregated information. And the link that's included in this PowerPoint will take you straight to that site. And then we also have individual school and district summary reports. And these are sort of those one-page, we call them orange and blues, go Bronco colors, that include the median growth percentiles overall by grade and then by disaggregated groups for the past couple of school years to really be making good comparisons over your growth trends. And so those are also available online. And then the individual student growth reports are sent directly to districts to be distributed to parents that help explain the performance and growth of their students and sort of show a 3-year time frame and what progress a student has made. And so this is just an annotated version of, I know it's a lot, those individual school and district summary reports. Just ignore it. It's available for people who want the explanation. We'll take that out next time, Katie. I can see your face where you're like, oh, why is that in there? Sorry. We were trying to explain. So I do want to sort of make a note about the on-track information, because we have spent so much of the past year having conversations with you guys about this. And so know that the on-track results for the English language proficiency assessment have been included in the student file released to districts and will be included for points on the 2019 performance frameworks. So last year we included those for informational purposes. We built them, you know, a couple years ago when we were constructing the ESSA plan. So those are ready to roll. And then the on-track results for the CMAS content assessments that we've been having lots of conversations about have been included in the student file released to districts and will not be included on the 2019 performance frameworks that'll be released. Is that next week? And our plan is that we will probably provide an informational report sometime during 2020, and to provide information about how those results would look, and then we'll include them for informational purposes on the official 2020 frameworks, and then incorporate for points in 2021. Again, that's all part of the conversations that, you know, we've been having over time. So I think that there's a little bit of flexibility around that. And then finally, what is not currently available is the PSAT, SAT growth information. So as we said, that has been delayed, but we are planning on releasing that on August 21st to districts and then on August 26th publicly. So hopefully it's not too much of a delay. And then as always, we sort of limit our reporting of small student populations due to privacy concerns. So on all of our reports, we don't display any numbers that have an N less than 20. And so then I'll just end it with asking if there are any other questions.
Thank you. Before I take questions, I want to thank you and your staff for all your hard work for getting this together.
Thanks.
This is a lot. You were wise to give us this much so that we have some appreciation, because we know it's not included. So thank you very, very much. Questions, colleagues? Board Member Goff.
Advance thank you to Ms. Kowski for answering it, because we had a conversation about it. We had a conversation earlier this summer. Question is there any change or general information that might be of interest to everybody about including the SAT score on transcripts in relation to college admission issues? And, you know, I guess maybe parents, especially in schools, would like to know what the flexibilities are, if there are any in-stone requirements, how are those determined, what avenues do parents have, especially about finding out and putting, and having input into whatever happens between their district and their student paperwork.
So Colorado had a requirement in legislation going back for years. I'll just say, a long time ago, way before I got here, which has been now almost a decade. And in that original legislation, there was reference to including on transcripts the performance on the college entrance exam. And we heard similar concerns to what you are sharing now. And we were able to have conversations with folks, and legislators chose to revise that to say you must include on the transcripts the results of the college entrance exam, but students who take the college entrance exam also on their own dollar, they can choose which one to put on their transcripts. So a lot of the challenges that we hear about are students who take the state administered exam in April, then they go and retake it in June. That June score is higher than the April score, and students want to put the June score on instead of the April one on. So in that legislation, it was revised, and we had that for a few years. Then a couple of years ago, two different sections of the law were brought together, and the language, I'll say, reverted back to the prior language. Now, I can't speak to intent. Well, I'm going to hint at intent. I don't think it was done on purpose. I could be wrong, but I don't think it was. I think they were merging two really big pieces of legislation, and that newer language got lost in the process. I don't know that.
So what happened?
So in terms of your question about what can be done, right now in legislation, it does say essentially that the score achieved on the state-administered college entrance exam is the score that is to go on transcripts. A way to get that revised would be for folks to talk to their legislators and revert back to that second set of language that said students can choose which score they want to have go on their transcript.
Or not have?
Right now, it's a legislative issue, and how the legislation is written is what needs to be followed.
Which would allow flexibility. The conversations with legislators would probably touch on the whole thing about what is a school district's interpretation of it? Is it required to be on there or not? And the change, I'm not going to go into this all detailedly. But the change in recent months, recent years, has been that the SAT is not even being considered by a vast majority of, at least public institutions. So it's not.
I'm sorry, I didn't
mean,
mean
they're
to
not-
interrupt you,
They're not
but
putting it in priority mix necessarily.
So I just want to provide clarification, and I do apologize for interrupting. I have not seen any indication that public institutions are not accepting the SAT, and in fact, if I look at the list of institutions that accept the ACT and those that accept the SAT, there is overlap. Now, I do think that there is, in some places, a misconception, because Colorado has had this long-standing tradition of ACT, that only the ACT is accepted, but Colorado institutions have accepted SAT scores as well. And I would suggest that across the country, if an institution is accepting one, they're accepting both. There may be some exceptions to that, I just haven't seen any.
I think the confusion or the question on the part of the parents that I've talked to about this has been whether or not, it's not a matter of acceptance of it, it's a matter of requiring it, whether it's ACT or SAT. And so parents, there's been confusion in some parent community whether or not the district can say we are going to put this score on your child's transcript or not, if they request that it not be there. So that it's a matter of interpretation of what's required and what, it really doesn't have anything to do with whether the college will look at it or not. It's whether it has to be required, whether they can be told it's required for this admissions process. That's what I understand the questions to be. So, anyway, thank you.
Thank you so much. Thanks for all your hard work. We are grateful. We will have questions. After we
Expected.
Yep. So much. I'd like to now move to item 5. Nope, item 7.01. State Board will now vote on whether to rule on petition for declaratory order filed with the State Board office. Ms. Carlson, would you please provide us with a brief update?
Yes, and good afternoon, board members. You have some rules that are not frequently used, but that provide for any party who has either an area of concern or confusion regarding the application of various aspects of Title 22 or your rules to come before the board and seek an order resolving a legal question around which they believe there's an ambiguity or some need for certainty. And it's under those rules that the petition has been filed that is pending before you. It's filed by Aurora Public Schools asking for a declaration from this board as to whether or not it needs to follow the statutory process to act on the new, it's not as new now as it was back in June, but we've all had a little bit of a summer break, the new memorandum of understanding tendered to it by Hope Online. I won't belabor the facts because I know you all have those materials, but the threshold question for you is, unlike many of the other matters that come before you where you don't get a choice as to whether or not you're going to decide them, your threshold question is whether or not you want to exercise your discretion to entertain the petition at all. And that's entrusted to your discretion by rules for any reason, but a couple of the reasons that are available to you and specifically invoked in the rules are whether deciding the petition will resolve a live controversy with some certainty versus just providing some sort of an advisory opinion that doesn't, say, end the dispute. So that's the threshold question. There are a couple of things that would flow after that if you decide to hear it, including that right now the only named party is Aurora Public Schools because they filed it, but we do have a request to intervene from Hope Online I don't believe an opposition was filed to that request, so if it was going to move forward and you're going to entertain the petition, you would want to decide on that intervention that is sought by Hope and how we handle it going forward.
Thank you. Colleagues, do you have any questions for Counselor Wilson? Do I have a motion?
Thank you. Madam Chair, pursuant to Rule 104 of 1.04 of our procedures for declaratory orders, I move that we decline to rule on the petition for a declaratory order.
Thank you, that's a proper motion. Do I have a second?
Second.
Thank you. Any further discussion, colleagues? Would you call the roll, please?
Board Member Durham,
Yes?
Board Member Flores,
Yes.
Board Member Goff,
Yes.
Board Member McClellan,
Yes.
Board Member Rankin, Board Member Shuffle,
No.
Board Member Schroeder.
Yes.
That passes 5-1.
I think we've lost Board Member Rankin at sea.
Yes. And so if we can get, it would be great to have at least 6 members here to vote for this, or if we know what Steve's vote
Item
is
five,
gonna be.
yeah, item 5.01.
If we can
The
move to
next
it
step.
quickly, or.
And then we can answer questions.
No, Madam Chair, I apologize. I have to leave a little early and have about a 3.5-hour drive ahead of me for a meeting this evening. The only questions I had,
Let me introduce real fast.
oh, yes,
So
good point.
folks know. Let's try to find it. I can get that lost.
Shuffle.
Indeed, that was lost. So this is a request that we rule on the accountability. Replacement accountability. I did not have that.
I don't have, I never did have, or I deny having today's script. Doesn't mean I didn't have it, I just deny it.
There it is. Got it? You know, when I was chewing potato chips, I turned it off. The next item on our agenda is an update regarding the statewide accountability measures for the Colorado Public School System. Commissioner Amthus.
Yes, I think we'll go directly to questions, so Mr. Durham can get his questions answered and then possibly submit a vote. But these are, we can separate these from the other decisions you've made. These are technical updates and a few other additions that we've had that we will go through, but want to let Mr. Durham ask his questions.
Well, I certainly don't oppose this, so, but I did have some questions, and I think starting on page 5, I think is where my notes indicated they would start, but, and let me see if I can find questions. Oh. One of the questions is in calculating dropout rates, someplace in here, and I'm trying to remember now where it is. It sounds like we were allowing, counting as non-dropouts those who are going to graduate within 5, 6, or 7 years as opposed to just 4 years.
5 years.
Is it 5? And I've always, I think at some point that gets to be a little, unless we're calculating those rates in arrears, are we trying to project those? Do we know? I mean, what is the dropout rate calculated on? If they don't graduate, I consider them a dropout.
Do you know, Marie, do you know?
Marie, speak to that.
Well, we do use a 5-year, a 6,
Yeah,
or a 6-year rate.
I just can't
but
find it.
just-
I've underlined a number of things. I just
That's one
don't.
of the things that didn't change, so I didn't.
Yeah,
I
it didn't
focus on
change. I just wondered.
So the graduation rate is where we have the 4, 5, 6, and
Right.
7-year rate. And if at any point a student has dropped out of school, they get counted against the school's graduation rate at any
Right.
point in all the time that they're in. I guess so if you're asking about the dropout rate, that
Yeah.
one's actually
Maybe
calculated.
I'm confusing the
different
two.
than the
I'm
graduation
confusing the
rate.
two.
It
Yeah,
is.
they're two different
So it's
rates.
just a graduation rate. So when is that calculated? Is it recalculated every year if somebody graduates? Is it a projection? Because I think the words I saw in there was a reasonable probability or something. Is that what I saw?
Okay, I might have to go back and look at that
And I
again.
read this over the weekend, so I wish I could find it real quick.
In general, the graduation rate is calculated in a lagged basis, where we
Okay.
look to see, in the previous year, who has graduated, and then check to see if they have enrolled in a school in the following year. And if the student does not appear, so if the student had existed and not graduated in the prior year, and they are enrolled in a school the following year, we assume that they are continuing on to like the 5th year, the 6th year, the 7th year. If they do not reappear, that is when they get flagged as being a dropout and count against the school's graduation rate for all of the years moving forward.
Can we find them if they go out of state and go to high school?
So we ask that the district submit sort of additional enrollment information.
Such as if the transcript was requested by a school
Exactly.
in California or whatever, okay.
Yep. So we have sort of those two layers of checks. Like we check to see if they're anywhere in state, and then if they've been out of state, we hope that the sending school has received some notification that the kid has enrolled elsewhere that they can provide to us.
And then on page 10 of, I think it's existing rules, and I don't think there's any change. 5.07, you allow 8 weeks for people to refile a notice of appeal of their accreditation rates. I think I know that's puts a lot of pressure on the department. And I wonder if we shouldn't shorten that a little bit so that if schools are going to appeal, need to do it at an earlier point.
There was an
than 8
explanation in there
weeks.
for the 8 weeks versus a specific date, and that was that they changed the date when the materials were sent out to the districts, and so the districts requested, this is basically input from CASB or somebody, that they have that much time to appeal. And we can change that, but
Is
that
that,
was that was what they wanted.
And it's more of a, but it's how much a burden
I
is
know.
that on the department?
A lot.
And it should be obviously measured from the time they receive the data. So 8 weeks just seemed a little long to me. And I have a feeling most districts pretty well know if they're gonna appeal or not within a relatively short period of time. So that would it be helpful to our staff to be able to make that 6 weeks or 4 weeks or some other number?
Yeah. So at this moment, we have sort of a draft request to reconsider process. So districts who know that they are going to appeal submit a draft of their appeal, which is then reviewed by CDE staff and then provided back to the districts. So then they can then either make whatever changes they need to their appeal and resubmit for the final appeal. So we have heard from districts that draft review process is extremely important to them, and I think that is probably the biggest reason to have that 8-week window, because it gives the district time to write a draft, submit it to us, have us review it, submit it back, and then have them to come back again.
Does it result in sometimes them withdrawing an appeal, or does it sometimes result in you guys in the department saying, you're right, we made an obvious mistake, and we're gonna correct that?
Usually it has resulted in the district withdrawing their appeal, and realizing that they don't necessarily have an argument that,
So they don't meet the criteria.
that they don't, doesn't meet the criteria, exactly.
Okay,
I think we're okay with
Yeah,
it.
okay.
In terms of.
all right.
Was there anything else?
No, those were I finally found on schedule to graduate within 4, 5, 6, or 7 years on page 11. But no, I think that pretty well covered the questions I had.
So are you comfortable submitting a vote, what your vote would be on this, or?
Yeah, do we need,
Well, because Joyce is gone, and just if you have to leave before everybody else.
yeah, I mean, I'm a yes vote on this standard.
Okay, so now, Alan, do you want to continue on?
Yeah. So what we'd like to do is, there's a couple of things. So in June, we talked to you guys about, there's a READ Act requirement that was to have it posted in the UIP. That was, it's in statute. It's kind of a technical change, actually. So, oh, move the slide forward there. Sorry, thank you. So that is the first thing that we'd like to talk to you about. So I'll turn that over to Katie Lanahan and let her talk through that a little bit.
So this slide, you've seen this slide before, but the changes to these rules are incorporating updates to legislation in a few different areas. And then most recently, in May, the Senate Bill 199 updates to the READ Act included some new requirements for UIPs around districts and charter schools reporting their curriculum and assessments. So the new changes that we have in this latest version that you see, it just restates what's in statute. It doesn't go beyond statute or provide any other detail.
I think the only other thing we added was just the next piece here. We got some feedback asking that districts wanted some consistency in how often you all adjust these rules. And so this was the, this red sentence here was our response to that we added in. And so just wanted to make sure you are okay with that.
Okay, so I missed this. Is this 3.02?
Yes.
Yes.
Yes, so we're just going through this one change and this.
What change did you make?
So in response to what we had talked about in June, you guys had talked about actually putting in a provision that if we changed cut points, we made a change to the performance frameworks, that we tried to hold a time frame of 3 to 5 years is what you had talked to us about.
3 years.
Yeah, 3 years. So what we had put in is, when considering whether to reaffirm or revise existing targets, the state board will weigh heavily on the importance of allowing public schools, districts, and the institute the opportunity to make improvements towards consistent and predictable targets. We actually have one more version of that after having some conversations with some and thinking through this and talking with our team. We actually came up with another version that we can share with you, but it really depends upon how you guys want to view this. It is by law that you guys have to review every year. So, but there's some language that could be placed in this. So we do have another version if you'd like to see another version, if this isn't what you want to see.
Give me a choice.
Okay.
It just maintains board discretion, does it not?
Well, what Mr. Dillon said to me the other day when I brought up the notion that I thought it was the original was kind of mushy.
A softball.
Right. Softball, that's good, mushy. Was that we don't have the authority in the legislation to say it's gonna be for 2 years, for 3 years.
Right.
We just can't do that. We're required to check it every year. And yet we do want to say to districts, we're probably gonna make a change this year, but we'll look at it next year and look for some drastic information that would make us go back and do something different, but our intent is to maintain stability.
And so, in that conversation, there can be, language can be put in there that, recommends that whatever the current board, once they made changes, would attempt to wait for 3 years. And you never know, there may be something that comes along that keeps that from happening, but at least.
Another ESSA.
Right. But as a board, you guys certainly can have that conversation and decide if that's something you want to do, and we can put language in there to remind us of that, so.
But if a test takes 5 years, at least, at the very least, 5 years.
Your last one better? Tell me why you like the A better, Mr. Dillon.
Actually, I'm pretty open to whatever, I think it speaks to the field. It says that you guys.
That's what I wanna do.
Yeah, and it really, you guys are saying that it does matter to you to give the field time to implement the changes you're making, and, kudos to you guys for doing that, actually. So I think either way it's written, I think it's really more your comfort level of how you feel about that. It's obviously not binding, but I think it's a good reminder, actually. I appreciate your willingness to take a look at that.
How legal do you think we are?
We can defer there, but I think since it says the board is encouraged, I think it's just indicating your intent.
Colleagues, what are your thoughts? I had thought that we'd come to some kind of a decision that we weren't going to change it. Turns out we can't do that legally. But I would like the field to have some confidence, well, actually both things, to have some confidence that we are going to let them have an opportunity to do this for 3 years. But also then they are on notice that in 3 years we're going to pay a whole lot more attention and request a lot of information, more information than usual, and look at alternatives, where should we make changes, et cetera. But I don't know what you guys think.
3 years for what? For the task, for?
For the cut points.
May I ask a question?
Yeah,
Madam?
please do.
Are you asking which version of this language we prefer, A or B?
Or the mush, or the stuff, not mush, forgot what's what. Or what was in original.
Well, there was nothing.
Yeah,
Oh, there was
or you
nothing
just
in
don't
the
put
original.
anything in.
This is like
Right.
a little spring on us
Okay.
today, which is.
I think number 8, the first one is better. I don't think we should put 3 years in there.
Board Member McClellan.
Thank you, Madam Chair. So, if I understand correctly, either of these versions would maintain board discretion in the event that we were to have to make an adjustment that we did not foresee. For example, if there were federal legislation that we needed to comply with in a shorter time window, this wording does not prevent us from taking responsible action that we could not have foreseen would be necessary in a shorter time horizon than we would have anticipated.
That's correct.
Okay, thank you.
Madam Chair?
Sure, yeah.
So why put in the 3 years? I mean, in number 2, and I'm more for A than for B. But
It doesn't help. I'm trying to give a message to the
Yeah, there's-
field that we are not gonna look at this every year unless there's something really drastic happens. That we will give them a minimum of 3 years of consistent targets.
well, that's taking 3 years. We have sunset laws, and we have, and those are sometimes 5 years or whatever they are. And I think, stating 3, and I don't know,
At least
that-
3 years.
Well, number A, rule A says it, that we will weigh heavily the importance of allowing school districts and the institute the opportunity to make improvements towards consistent and predictable targets. Now, why not leave it at that? And then,
Well, that's okay. If
If
the
we have
majority
to.
of you wish that, as I said, my goal in this was to give as much assurance as possible that given there might be a totally new state board, that in our rules, we've suggested.
so why put 3 in it? I mean, I think A would be sufficient.
It's just more mush, is
This
my
end.
interpretation.
It's our
Board
mush.
Member Deb.
Yeah, my thought would be that we have discretion either way, giving the district some stability for 3 years, makes some good sense. 3 data points so that they can look at trends, and we're not handcuffed anyway. So
We're not
I guess
handcuffed.
B makes a lot of sense in my thought.
Board Member Goff?
I agree. I find it, what do you, softball-y?
Yeah, I forgot
Softball?
the word softball.
Mushy softballs.
Mushy.
To say will weigh heavily, I mean, what does that mean? It's kind of like it feels like a conflict in terms without being, I like B because you can be more specific without being bound into it. And it's got a more consistent, compatible structure of positive, rather than weigh heavily. It's hard to determine what that might mean. What does that mean? I don't know.
Yes.
What if next year, for some reason, ACT had a better test or whatever? I'm not saying that I think that's the case, but what if something like that happened and we have to make a decision about a test?
We're not prevented from that.
Yeah, this just says,
We'd
and
still
if
give
we-
them 3 years, even though,
If we went to a
No.
different high school test, then we would have to look at a different cut score for high school. That still wouldn't affect our cut scores for CMAS, for example.
I think that number A gives more reassurance to school districts about,
Okay.
but
Board Member McClellan?
I can live with either.
Board Member Rankin, are you by any chance back?
They've been texting her and can't get a hold of her.
she's probably asleep
All right.
if she's where she is.
So, is there anyone here to testify? I believe there are a number of people here to testify, am I right? Holy smokes, I
Those
cannot
people
read
signed
this.
up earlier this morning. We're not sure if they're all still here.
Diane,
It's very hard to read.
I think, Madam Chair, I think those were the names of the people that presented during the charter appeal, and I think they might have gotten confused where they needed to sign up, but I'm not positive, so we should double check, but it looked like from where they were, that that's.
you can't testify in a charter appeal.
No, I know, it was the names of the people that were up here at the table for the charter appeal.
Scott Smith, yep. Well, Kristen Schmidt? Was that one of the people?
Do we have Kristen Schmidt here?
Colleen Doan? Carolyn Bertner? Okay, oops. That's a
Yeah,
speaker.
there's just a signature that we can't read, so. Anybody here to testify?
I don't think the agenda reflected a rulemaking hearing being scheduled right now.
no,
No, it doesn't.
right.
We had a hearing on these back in June.
Right, okay,
Yeah.
so we can vote even if
Yes.
they're.
Okay.
So we have two votes, I believe. One of the votes is to repeal the laws we currently have, the rules we currently have, and then to replace them, am I correct?
You do not have to bifurcate those two, because my guess is you only want to repeal the ones you currently have if you're adopting the substitute. So if you want to vote to repeal and replace with this particular content, you could do that in a single vote.
And
That would-
that proposed motion would be? I move to approve the as amended, because we did amend with one sentence. We
Which
decide
one,
which one
A
that
or
would be.
B?
Of the two here,
Mhm. Those are amendments, right, to what was
yeah,
proposed?
if you want to start out by simply voting on the amendment, and then
Oh, okay.
voting on the proposed new rules as repeal and replace with the new rules as amended. You could do it that way.
So could I have a motion on the amendment, please? The amendment is to add the sentence in either A or B. Please.
So I move to, but this is just for the amendment.
Correct.
To amend the rules as stated, but add the additional language in option B.
Would you be good enough to read that, please?
In order to allow public schools, districts, and the institute the opportunity to make improvements toward consistent and predictable targets, the state board is encouraged to keep targets the same for at least 3 years before revising them.
Thank you. It's a proper motion. Have a second from Board Member Goff. Would you call the roll, please?
Board Member Durham?
Excused.
Board Member Flores?
No.
Board Member Goff?
Yes,
Board Member McClellan?
Yes.
Board Member Rankin? Board
Ms.
Member
Yancy?
Scheffel?
Yes.
Board Member Schroeder?
Yes. So
That
that
passes
amendment
4 to
passes.
1.
Thank you. So now I need a motion to approve revisions to the rules for the administration of statewide accountability measures for Colorado Public School System.
I just, Madam Chair, I had one more question about the current proposed rules. Do I
Good.
do that after the?
Either way,
Okay.
you can make the motion or, and then discuss it, or
Okay.
do
Can
you
I-
want to change the motion?
I might, if I can just ask
Okay,
this
then go ahead,
question.
then go
Could I
ahead.
ask this question about 5.04, and it's several times in the document? When evaluating attainment of performance indicators, the department shall place greatest emphasis on student longitudinal growth and post-secondary and workforce readiness. That wasn't in there before, or it was?
That's old language.
That's old language. But yet, didn't we, it seems like we've been talking about the extent to which it should be achievement or growth, or, I mean, so does this preclude us from really looking at those valences and having flexibility, or does this kind of tie our hands to some degree, and is that really what we want, I guess?
I think if you left the language as is, it would tie your hands a little bit.
Mhm.
You
And
could
that's
always
how
go
we
back
have been
and change
doing
this
it.
language, or you could remove that language.
So I just wondered if others had a question about that. That mean growth percentile is an interesting metric because it's so relative. You know, a 50 mean growth percentile means that half the students,
By definition.
yeah, by definition, that the student or the group aggregately is what? Making the same progress as all the other people in that group? And if it's above, they're making faster progress, and if it's below, they're making slower progress. Is that right?
Basically, yes.
Roughly. Do you have a better definition? It just seems like such a relative statistic, and if we say that that's what we want to land on, I don't know if there's some other way to think about growth. Because that means if most people in the state aren't growing, you can look great on growth. I don't really like that. I mean, it seems like growth should be on-track growth, which you referred to. If we want growth to go somewhere, we don't want it to just be this relative statistic that says, a lot of students aren't growing, I'm growing a little better than the ones that aren't growing much, so I look good.
So, I mean, I think this gets back to a lot of conversation, that other set of conversations that we're having in terms of sort of the system efficacy and the fact that this is used in the performance frameworks, which is judging which of our schools needs support the most. And so I think the original intention with growth was to make it so that all students could show growth. Most of the other growth models that are available to us don't allow growth sort of at the upper end of the scale or at the very bottom. They don't allow for meaningful differentiation. But whereas the current growth model that we have does allow for that, but we have chosen to reset that median growth percentile of 50 every year so that it is renormed every year. But there is the possibility that if you're interested in pursuing this, that we could baseline that in essence and hold that steady. So every year would be compared to that baseline year, so then 50 would no longer shift annually. So there is that possibility. I also think there's the possibility, as we've been talking about for a while, in terms of on-track growth and incorporating that into the performance frameworks, potentially at either at the rate that we currently have or at a greater amount.
It just seems like if we're gonna say to ourselves, we really wanna emphasize and put the greatest weight on those two things, I think we should have it be on-track growth. And then I don't know how I feel about post-workforce readiness and only because I'd like to see how it's being defined currently, and is that really the right focus also? I need to look at a definition of what that entails.
And the definition for
High school
post-secondary and
graduation
workforce
rates.
readiness actually is continuing to change. We have additional
That's what I
legislation
mean,
and
yeah.
additional measures.
So I feel a little,
Mhm.
so I feel a little uncomfortable with that language in there, only because the way it's stated, it's very relative, the growth metric, and then post-workforce readiness is like a moving target. So I
Dr.
don't know.
Shuffle, can you tell me again where you are in the rules?
5.04.
5.04, thank you.
And it appears also at 8.03, that same line.
Well, it started
Yeah,
3.04.
Earlier, yeah.
Was the definition.
Right.
If I understand correctly, I think you're asking to go back and start re-looking at some of the decisions that we've already made, or the legislature has helped us make.
Well, I'm just trying to think, we just looked at all this achievement data, and, we're trying to move the needle, we're struggling to see it move. And when we say that
it's this relativistic metric of growth, which means if most kids aren't growing much and we grow a little better, you know, as an aggregate group, let's say, across groups, it might look good, and it really isn't very good. And then post-workforce readiness, if I thought there was a good, stable, rigorous definition, I might feel better, but I feel like it isn't. So that's what, I'm just thinking, we're
Yeah,
tying
unfortunately,
ourselves to these metrics.
Post-workforce readiness has been defined to a large extent by the legislation. It's just the percentage that I think we could change, right? Is the percentage in the legislation? No.
No.
But
yeah,
the actual
percentage
definition is legislated.
Yeah, the metrics that
And
we
they're
must
messing
include.
with it every year.
Right, I know. So I just, do we wanna say that we have to put the greatest weight on those things? Maybe we don't wanna say that. Maybe we would say it
The
would,
weight,
it would
the weight is
comprise.
not in here, right? The weight
It
is.
says we have to put the greatest
Emphasis.
weight.
Well, in
The
growth.
greatest weight, yeah,
Well,
that's in the
emphasis weight.
legislation. That is in the legislation that the greatest weight has to be on
Is
growth.
it?
It's
I
just
don't
in the
think it
rules.
is.
Yeah, I think
Oh, it's just in the rules?
Well, but,
Yeah.
but that's what we said to the feds too, in our plan.
I mean, and I will say that that has been something that we have heard clearly from stakeholders,
Oh, yeah.
is that they do value growth in PWR as, for accountability purposes, as the most important metrics, that really allow them to show the progress that, or the impact that they as schools are having on their students. I think that if, there is the possibility that we could move forward without this language, but I do think that you would get a significant amount of pushback from the field around that.
Could
That
we
has
say-
been one of their primary concerns that
Could we
we've
say
heard.
will include as opposed to greatest emphasis on? I mean, we're
The-
already including it.
The legislation requires us to
Yeah.
include it. I think they are concerned about shifting the focus away from growth, which has been sort of the basis for the accountability system that we currently have and how we built it and why we built it the way that we have. And their interest is, I would say, in maintaining that focus.
I would say if you, I would say if you made that shift, I would actually recommend probably not voting today so that they can weigh in, because if they feel that a last minute change has been made right at the last minute and then not all board members are here to vote on it, I would say then we should not vote today, have another hearing so that you can hear from them, because I think to Marie's point, that probably
That would,
be substantial for them.
May I ask a follow-up?
please go ahead.
Would, how about on-track student growth, or is that such a dramatic shift also?
So, I mean, I think at this point, sort of on-track student growth, at least from my perspective, has been combined into the growth reference here. I think that is another point that we have had conversations with you about the weighting and how much to weight it or include it. I think that right now, some of the concern with the field is that it is a new metric and it is on a new assessment, and they didn't want it to be weighted too heavily initially. But again, that is something that we can revisit. I mean, that's a conversation that we've sort of had multiple pieces of at various board meetings, but we can come back to it.
No.
So maybe just one more comment. I guess one thought, this is a premise question. If our premise is that high-stakes standardized tests drive student achievement gains, and there's a lot of different studies out there that say it can help a little bit, not a lot of studies that say helps a lot, but that's why we're doing it, shining a flashlight on issues where we hope to see year by year gains, then we'd want our metrics to help us get there. And I just don't know that the ones that are in here help us get there, but I'm sensitive to the fact that you need more feedback from the field, but I just,
If
we
you
just
have a
looked
lot
at
of
all that
growth,
data.
and you don't get to achievement, what the heck's going on, right? I mean, ultimately, you assume that it's going to get you where you want to be, which is that kids are professional.
But if it isn't on-track growth, I don't think it does. Am I right? Statistically, if it isn't on-track growth.
Well, it could still get you to achievement, it just might take a little longer.
Yeah.
Board Member Flores.
And one of the things I think we asked yesterday was that, because you wouldn't believe the statements that were made by the people that were here, that made statements to the effect that the field wants growth and that it was heard loud and clear, then I think it was asked of Dr. Dillon that he ask or get some statements from the field about whether, growth was important and such, and that we wanted to see it in writing. Am I correct? I think I remember that.
Yeah, so at the very beginning of this process, we reached out, we got a lot of feedback, and we got a lot of feedback from the field that they value growth.
Right.
Yeah.
Right, but then yesterday, I remember that there were some doubters, some doubting Thomases out there on the board, and they wanted something to ask the field again to have it in writing. We heard it, but they
That was
wanted.
about distinction.
Yeah,
Wasn't that
yeah,
about-
that
was
whole,
about
that
distinction,
whole
Val.
part was around the distinction component. But we do actually have it in writing. It was sent by Case Casby around, the importance of growth.
Right, and I thought that, well, I won't say.
Yeah,
I'll
and the
leave it
technical
at that.
advisory panel made that same statement as well, yes,
They
thank
did.
you.
Right, and how much
And
they
actually, when
valued
it
that.
came to the growth to rate to standard, we actually pushed harder than the advisory council did. The board did in their request, when they wanted 3 years and we requested 2 years. So I think my sense is that this is a good place to go for a while. And I agree that if we took the statement growth out of there, we would be bombarded, because there's the perception that we get the kids at a certain place when they come to school. We want to grow them. We don't want you to keep measuring where they came from. That's the rub. But I think it's an important question to constantly keep asking, are we getting to where we want, which is ultimately proficiency. Go ahead.
Can we redefine how we assess growth? In other words, we can put this language in here, but the algorithm you're using to estimate growth is a certain one. I mean, so we have this language in here. I mean, I guess that's more what I'm questioning, is the way we're assessing growth, a way that's gonna get us where we wanna go. It looks like year after year after year after year, we don't see a lot of change in our achievement. So growth hopefully leads us where we wanna go. If year after year after year, we still see these gaps, we still see these difficulties with achievement, then the question is that the right metric? Is that the right way of calculating growth so that we actually get where we wanna go? So the language is fine, let's say, but maybe we relook at some point in how the metric is calculated.
So we can certainly explore that. I think that I would be careful about confusing the identification system, which is describing what we're seeing in the performance of schools, with a system to improve the performance of schools. The performance frameworks themselves don't actually change
Right, that's
anything.
just- the thermometer doesn't change.
Exactly. And so it's sort of the future steps of the unified improvement process, and then all of the, the turnaround network and a lot of the other support work that happens is what is supposed to actually, push change and improve our student outcomes. So I think that, honestly, as you said, Dr. Scheffel, just changing the thermometer won't necessarily give us a different view of what's happening within our schools. I think it's really focusing on those supports and identifying the schools that could benefit most from those supports and really pushing on that and potentially funding it. That is always the challenge. And there was a mention, I think Board Member McClellan mentioned yesterday around the governor's office potentially having some additional money that they're interested in putting to those efforts. So I think that would actually be the conversation if we want to try to push the needle instead of changing the needle. But again, we can also explore other alternatives. I think that as this past year has shown us with creating a new on-track metric, it is a long and detailed process that will just it'll just take a lot of conversations.
And actually adopting this does not prevent us from going back.
No, not at all.
And looking. I think the questions that you're asking would require a whole lot of scenarios with different.
Yeah, we would have to investigate extensively because there are so many different sort of ways to look at growth, and they all have their own pros and cons. So again, it would just be a much larger conversation.
This is when you don't have anything to do.
I know. That's never these days, but
No, but
sure,
I think
can
it's
add it in.
important to keep asking those questions. I appreciate that.
Okay, thank you.
Anyway, are we ready to adopt these? Have a motion? Please. As amended.
I thought we weren't going to do it until.
5.01.
Okay.
As amended. Here we go.
Madam Chair, I move to repeal and replace the rules for the administration of statewide accountability measures for the Colorado Public School System 1 CCR 301-1 as amended.
I think that's a proper motion. Did we get that right? Do I have a second, please? Please.
Well, can I ask something?
Yes, just second it, and then you can ask.
Does it include, does it include what we did a few minutes ago with option B?
That was amended. That's the
Yes.
amendment. That's the
amendment.
That's the
So
as
when you
amended.
said as amended,
As amended with option B.
just certifying.
Yeah.
Thank you. I appreciate
Second.
that. Call the roll, please.
Board Member Durham, excused. Board Member Flores.
Yes.
Board Member Goff.
Yes.
Board Member McClellan.
Yes.
Board Member Rankin, excused. Board Member Shuffle.
Yes.
Board Member Schroeder.
Yes.
That passes 5-0.
And Steve said yes too. Before you
Yes, he
left.
did. Steve said yes, and he and I discussed so I think he'll actually be happier with B as well.
Yeah.
I think since the motion to amend didn't come till after he was gone, I think it's safer not to count
Do
his.
not include
vote.
him in the
Yeah.
count.
Thank
Okay,
you.
But he did say
It's not
yes.
changing your outcome, so if you're
Right.
comfortable with that.
No, keep us safe, please. I hate to ask, where are we? Well, we're supposed to recess for lunch. We don't have to. You haven't eaten? Okay, so you get to recess for lunch. We were supposed to get a board report from Board Member Rankin, except she's out to sea, so we'll get that next time. So the only thing that I would bring to your attention before we adjourn is two things, actually. One, and I'm waiting for the commissioner to give me the go-ahead, but as we look at the schedule for October, where we have only one day scheduled, could we reconsider the October meeting and have it on Tuesday and Wednesday? I
think-
got the head shake.
Well, so we did, I went back and forth with them. The holiday is actually, it would have to be Thursday, Friday, not
Oh.
Tuesday,
Oh, I had that
Wednesday.
wrong.
So-
I thought it was Wednesday.
Right. The holiday is Wednesday, which means we're only having a board meeting Thursday.
Thank you.
And so if you wanted to have the board meeting consecutively like you normally do, you would have to have it Thursday, Friday. I think as talking back and forth with staff, we were trying to say, would that be helpful, with the school hearings you're gonna be having? Problem is none of those school hearings are going to be ready for October. So I think, and we've already been assuming a one-day board meeting, so we've been sort of, making sure the rules, will come at the right time. I think if we can say we may tentatively have one, and if we have a little more time to go back and see if there are things we can shift up from November, and that would be helpful because it would provide some breathing room in November for the other things we have.
Right, I'm getting worried about
But-
December.
Right, but we just don't have enough information to make that judgment right this minute.
So the feedback that I would be grateful for from all of you is that doable? Is Thursday, Friday doable, which is different than what we discussed? If you'll look at your calendars and your work schedules. Yom Kippur, on Wednesday.
So the question is, we're going from one day Thursday meeting to
Potential.
Wednesday Thursday.
No, I had that wrong.
Thursday, Friday.
Thursday, Friday.
I'm gonna put a suggestion, we never set a one-day meeting for any month as far ahead as we determined them. I don't think we should be surprised that this happened. The work has piled up, there's a lot to
live and learn, but. So the schedule that we're gonna adopt next month has does it have a 1 day? It doesn't have any 1 day. They're all 2 days, except for December.
Yep, that's correct.
Okay, so we've taken your advice. What did we do yesterday? What? Yeah, that vote is next, right. And I think for July, for example, you put 2 days in for July if needed, and for December if needed. So we have done that much. It was only October that we really specified just 1 day. So that's a good suggestion. Thank you, guys. Thank you very much. Sorry.
Thank you.
So does everybody get a copy of the next month thing that you give me at a glance? You wanna hear about what we're doing next month? I swear I was there just a minute ago. We have hearings for educator licensing, workforce diploma pilot program, automatic enrollment in advanced courses grant program, administration of school health professionals grant program, and rules for the administration of the READ Act. Oops, those are notices of hearings. Then we have actual hearings, administration of the 9th grade student success program, and concurrent enrollment that we heard about. We have a charter school appeal, of waiver requests. Hope to get an update from MGT for the first quarter for ABS 14. Meeting dates and accountability clock monitoring. So I think we have a few things to do next month. Thank you all very much. Meeting's adjourned. What? 2 days? 2 days. Definitely 2 days. It's only October that we're talking about.
Yes, absolutely.